The committee will now resume. And can I please welcome representatives of the Cyber Security Cooperative Research Centre to give evidence. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
I'm Rachel Falk. I'm the CEO of the Cyber Security Cooperative Research Centre.
And I'm Anne-Louise Brown. I'm the Director of Corporate Affairs at the Cyber Security Cooperative Research Centre.
Thank you and welcome. Although the committee does not require to give evidence under oath, I should advise you that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Could I invite you to make a brief opening statement, after which we'll proceed to the discussion?
Thank you very much. I thank the committee for the opportunity to contribute to its review of the Surveillance Legislation Amendment Identify and Disrupt Bill 2020. The Cyber Security Cooperative Research Centre is dedicated to fostering the next generation of Australia's cybersecurity talent, developing innovative projects to strengthen our nation's cybersecurity capabilities. Central to this collaboration, which we foster between industry, government and researchers, creating real-world solutions for pressing cyber-related problems. We live in an interconnected world at a pivotal moment in time, a time in which the digital environment is challenging traditional notions of borders and sovereignty, enabling the free flow of information with the click of a button. It touches almost every aspect of our lives. And with the good comes the bad. Perversely, cybersecurity and the privacy afforded by its evolution has acted as a near-perfect conduit for criminals to operate unhindered. There can be no doubt that good security and end-to-end encryption is important and necessary in an online world. It enables secure banking, communications and transactions. Trust and good security should be intertwined. However, this security is being used as a shield by those seeking to do harm. In particular, the advent of the dark web, end-to-end encryption and other anonymising technologies have provided platforms via which pedophiles, terrorists, drug dealers, cyber criminals and armed dealers can operate undetected and protected. Make no mistake, they use security very effectively. We are now at a critical point where we as a society need to decide what kind of world we want to live in. Central to this must be the notion that all crime, whether committed online or offline, should be treated the same and the rule of law must be applied equally. If passed, this legislation will play a key role in countering serious cyber-enabled crime committed domestically and offshore. While the powers contained within the bill are undoubtedly extraordinary, they are proportionate and appropriate in relation to the scale and seriousness of the threat posed. Furthermore, such powers would serve to enhance the functions of the existing regimes which, while essential, are simply not fit for purpose when it comes to the proliferation of dark web-enabled crime. This bill presents a clear opportunity for Australia to ensure domestic laws with real-world consequences, are properly aligned with digitally perpetrated activities, allowing lawful access to data and devices where appropriate. It will help remove the cloak of invisibility serious criminals can currently hide behind online. And while I do not wish to oversimplify the challenges of the dark web and encryption posed to law enforcement and intelligence agencies, it does in many ways come back to good versus bad. As it stands, bad has the upper hand. The criminals are the ones with power. Privacy is a paradox. While vital, it can never be absolute, a paradigm well recognised within the UN's International Convention of Civil and Political Rights. And serious criminals should not be permitted to hide behind naive notions of absolute privacy. Such assertions are morally obtuse and fall foul of other laws which have existed for decades, such as telephone interception powers. We would not tolerate flagrant, horrific abuse of children in the house next door. So why would it be accepted on the dark web just because it's neatly tucked away and hidden from view? It can be difficult to quantify the real-life harms inflicted by crimes committed on the dark web and planned via encrypted communications. But take a minute. Think of Shannon McCool, a state government-employed family carer who ran a dark web child pornography site with 45,000 active members worldwide. A site where he uploaded images of himself abusing children aged 3 and under who were in his care. His youngest victim was an 18-month-old girl who raised alarm bells when she began stomping on her doll's head and grabbing its groin. Another victim, a little boy, has long-standing behavioural issues and hides under chairs when he feels threatened. Think of October 2nd, 2015, when New South Wales Police Accountant Curtis Cheng, a loving family man, was gunned down as he left work in Parramatta. The terrorists responsible for this atrocity, despite under heavy counter-terrorism surveillance, were able to plan for the crime on WhatsApp. And think of the Christchurch massacre. The terrorist frequented the dark web where he was able to buy extreme right-wing literature and nurture his sick ideology. None of these criminals had any right to privacy once they started to conspire and plan their serious crimes. Crimes committed on these platforms are not benign, nor are they victimless. Crime is crime, online or offline. In closing, at the Cybersecurity CRC, we are all about improving security and producing cybersecurity research with impact. But it is crystal clear that a line in the sand must be drawn. Support of strong cybersecurity and privacy, which is paramount, should not result in criminals committing crimes in private that go undetected. Privacy and security cannot trump the safety of our citizens. Our law enforcement agencies need the capabilities and the laws to keep Australians safe. Thank you. I'm happy to take questions from the committee.
Thank you very much, Ms Falk. I'll start with a few questions before I offer the call to others. We've heard from witnesses this morning, including the Law Council and the Human Rights Law Centre, who have concerns about the bill, and the Uniting Church and the Carly Ryan Foundation, who are strongly supportive of the bill. And their strong support for the bill stems in part from their concerns about child exploitation, and they gave us a good picture of the current state of online child exploitation. One issue which I think you're uniquely placed to assist the committee is to talk to us about the anonymising technology and the encryption technology which is being increasingly used by cyber criminals and the challenges that that poses for law enforcement. Could you just take us through the current state of technology and the use of that technology by these perpetrators?
Did you want to talk about it all?
Certainly. Look, the dark web is unlike the surface web. It's not somewhere you end up by accident. You need to have the correct software, a Tor browser or Tor software, the Onion router as it's known, to actually access the dark web. And when you're there, while it's not illegal to be on the dark web, when you're in there, you need to essentially know where you're going. So it's not like you can just enter a Google search and there you end up. You need to know, and quite often there, you know, especially in relation to, for example, child pedophile rings, there are relationships of trust that must be built up over time. A really good example, I guess, is in the case of Shannon McCool, which Rachel mentioned in her opening statement. And the site that he administered, it was called the Love Zone, and members of that community, 45,000 of them, were required to upload new material to retain membership of that site, new material every month, and if they abided by that, they would get access to special areas, so to speak, so with more graphic content. Now, the other thing that is really challenging, especially in relation to child exploitation material on the dark web, is the proliferation of live stream, which is especially difficult for law enforcement to crack down on, because quite often that activity is actually happening offshore. People within Australia that are using those services pay the same amount that they would pay for a packet of cigarettes to access that material. We hear about investigators literally watching children grow up in these films. It's really disturbing stuff. So that, I think in terms of disruption powers, that's where they can come in especially handy in disrupting that kind of activity. In terms of end-to-end encryption, which is obviously another huge problem that law enforcement faces, the way that technology essentially works is that, if there are communications between two people, then the encryption key is sent across, and this is, I'm not a technical expert, so excuse my quite high-level description, but only the people with the encryption key can actually access that communication. So that makes it exceptionally difficult. Then we see new developments, for example, things like the Phantom Secure phones, which were actually sold as a way to evade crime, to evade law enforcement. And within Australia, we saw, the Hells Angels use Phantom Secure phones to organise and orchestrate 2 murders. We've also seen EncroCrypt in the UK, which was another recent, that was sort of blown up recently, but another end-to-end encryption service that was basically touted as a way to evade law enforcement. So that's kind of the direction that things are moving, and that is why I think these powers are warranted, because as it stands, the laws aren't fit for purpose when it comes to fighting this kind of crime.
Okay. And then one more question for me before I go to other committee members. Some of the Law Centre representatives this morning said that one of their concerns is that the threshold of offences at which these powers would be directed is too low, that a term of imprisonment of 3 years is an insufficiently high barrier, and that it should be raised, in the Law Council's view, to 7 years. Given that the stated purpose of this bill is to get at things like terrorism and child sex offences, would you have any concerns if the threshold were raised? Is there any conduct that would be excluded from the scope of these powers that you would be concerned about if that was to happen?
Thank you. I think I did hear the testimony earlier today on that. I think it's important, yes, the 3-year threshold has been seen as quite low, and perhaps where the bill could be tweaked is classes of offences. I understand that might be problematic, but it would seem to me if there are offences like unlawfully importing or owning a whale or a dolphin is not the intended offence to be caught, given the necessary sort of potentially intrusive nature of the powers, that classes of offences should be defined. 3 years could be seen as low, so we would not object to that.
And would it be your preference that rather than raising the threshold in terms of the number of years of sentence, that instead that classes of offences are excluded, so that an example raised before that tax matters should not be included, but crimes against individuals should remain in even if it has a lower threshold?
I think to bring certainty to the application of the Act, because or the legislation, I think that's a key concern. Definitely classes of offences would make that clearer, because as we've seen, there have been a range of rather unusual potential offences caught in the bill, and whilst I'm sure that the police, as I said, do not have the resources to track down potential whale and dolphin importers, I think it would be helpful to then put classes of offences, and if they need to alter that, then they necessarily apply to alter the classes of offences. There's 3 years can seem quite low, and I think it's probably a matter of finding the right level, but classes of offences would, I think, go that way.
Okay, thank you. Mr Dreyfus or Mr Byrne, do you wish to ask questions to these witnesses?
I do.
Okay.
Anthony, do you want to ask some questions?
No, Mike, you go first.
Okay. Thank you very much to the Centre for attending.
Oh, I hope that wasn't Mr Dreyfus we lost there, but it might have been. While he reconnects, Mr Byrne, would you like to step in, or would other committee members like to step in with questions that you have?
I've got a couple which I can. This is Celia Hammond here, which I can ask while we're waiting for.
Thank you, Ms
Mr.
Hammond.
Dreyfus
if you could do that, and then we'll go to Mr Dreyfus when he's able to rejoin.
Okay, just picking up. Thank you very much for coming in and for the submission. I know you're just for clarity. Your main suggestion, you completely support the bill, but your main suggestion is with respect to the point that Senator Patterson was just talking to you about, which was restricting the amount of the offences. Is that correct?
Yes.
And how would you do that? Do you have a suggestion as to how that should be done?
No, we don't have an exact suggestion as to how that could be done. My understanding is classes of offences would be ideal, but there could be some technicalities in the drafting of that, and I think it could be problematic. So we don't have an exact sort of drafting suggestion, but it would strike me as obvious that classes of offences is a better place to start.
And I think the explanatory memorandum makes explicit note of the most serious of crimes, including child abuse and exploitation, terrorism, the sale of illicit drugs, human trafficking, identity theft and fraud, assassinations, and the distribution of weapons. So with these kinds of extraordinary powers, they seem like a proportionate application.
So perhaps that could be included within the legislation itself, not just in the EM.
Yes.
Yeah. My second point, do you have any concerns with respect to the definition in the account takeover warrants with respect to where's my what is it?
Network of criminal individuals.
Network. Sorry, yes, the network of criminal.
Whilst I think at the moment it does seem somewhat vague, and that may be a concern, I think it has to be necessarily so for the intelligence gathering purposes of that warrant. I have seen examples where it could then be a whole subsection or a class like all users of Facebook. But again, I would imagine from an ACIC and AFP perspective, and I'm sure they'll talk to this, it wouldn't be realistic to go after such a large group of individuals. So I think network, I would imagine, or one would hope that in the warrant that's necessarily defined. And maybe that's something that needs to be incredibly specific in the warrant process, that the network of individuals is duly defined and would have to be for the purposes of authorising the warrant.
And noting that within those warrants as well, there has to be a reasonable basis for the warrant to actually be made in the first place or to be granted.
Thank you. My final question is, in your submission, you contained a number of examples of illegal offences being tracked down by different authorities. You know, you've given drug dealing, the Cody Ronald Ward example, Phantom Secure, the murder of Curtis Cheng. How would these powers actually assist?
Yeah, look, I think that one of the key thing is that at the moment, investigators or people that are investigating these kinds of crimes are on the back foot. They are one step behind of the people that are committing these crimes. So what these powers would actually assist in doing is to help them get on the front foot and potentially help stop something terrible happening before it does or before it gets worse. I think, I'll go back to the Shannon McCool case, which is a particularly horrific case, obviously. But it seems quite ludicrous that essentially investigators knew that the administrator of the site was located in Australia, probably in Adelaide, and it still took about 2 years to find him. And the only way that they were able to find him was via a freckle on his hand. And the language that he used, which they were able to match from within the love zone to language that he used on the surface web, so to speak. So that is, amazing investigative work. There is no doubt about that. However, in that time, thousands of children were abused, and we actually have an opportunity to stop that happening.
So which of the three warrants would all three have assisted for that particular case to be resolved more quickly?
Potentially network access, network activity and account access, definitely account takeover.
Well, and I guess, especially in the case of Shannon McCool, again, it seems quite ludicrous that authorities have to ask somebody like that for access to their accounts. I think that most Australians would be quite shocked if they knew that was the case, that police have to ask access. Now, he granted access to those accounts, and that's how they were essentially unable to unravel the entire network, as it were. But if somebody refuses, at this point in time, there's nothing authorities can do.
Yes, I think it's easily
okay, thank you both, and thank you, Chair.
Thank you. I think that's an easily foreseeable circumstance where someone would refuse access, given what we know about the way these people operate. Mr. Dreyfus, I believe you've returned to us and you have the call. I hoped you had rejoined us, Mr Dreyfus.
Yes, thanks very much,
please.
Chair. The Centre acknowledges in its submission that these new powers, the data disruption warrants, the network activity warrants, the account takeover warrants, would be, and I'll quote from your submission, undoubtedly extraordinary. That's your description. At the level of principle, extraordinary powers should be subject to extraordinary safeguards. Would you agree with that?
With definitely safeguards as proposed, but it could be extraordinary, yes, depending on the level of intrusion, yes.
Well, to pin this down a bit, that in your submission you argue that the safeguards within the bill offer appropriate protection against the misuse of these extraordinary powers and legislative creep. Given that the powers would be extraordinary, and that's your description, what safeguards over and above the safeguards that exist in respect of ordinary powers are actually included in this bill?
Look, Mr Dreyfus, I would suggest that there are very strict reporting conditions within the bill. So there is regular reporting, and each time one of these warrants is made, I believe that the Minister for Home Affairs has to be made aware of that. There is also obviously the oversight of the Commonwealth Ombudsman and the IGIS, which we see as a particularly strong safeguard in respect to the legislation.
That's right.
Are there other safeguards that you'd point to?
No, not beyond the reporting and the authorisations. No, noting though that for the most part, even though they're extraordinary, these are intelligence gathering warrants, and then separately the agencies apply for either named person warrants or other warrants. So there is a multiple sort of, if you like, regimes of oversight depending on the nature of each warrant sort.
I don't think, just to be precise, that it would be right to describe the data disruption warrant as intelligence gathering, would it?
No, you're right, correct. It's not intelligence gathering. That is a slightly separate and very different authority and power under data disruption warrants.
Well, just going back to the safeguards for a moment, the two types of safeguards you've identified are strict reporting conditions, so that the Minister for Home Affairs has to be advised, and the oversight of the IGIS and the Ombudsman. They apply to so-called ordinary warrants under the Surveillance Devices Act right now, don't they? What I'm looking for is whether you can identify any safeguard in this bill that is in addition to the safeguards that already apply to, as you put it, intelligence gathering.
With respect, I would say that they are already extraordinary powers within the Surveillance Devices Act. Those are extraordinary powers, and hence the same level of safeguard should apply.
But it's not that there's any additional or extraordinary safeguards that are being applied to these new powers?
No, because they're all extraordinary powers.
No, no additional ones.
You've said in answer to questions from my colleagues that you'd be interested in some kind of restriction of the classes of offences. I think what you put at page 8 of your submission is this. You said the CRC submits that if offences that would and would not be captured under the regime were clearly carved out, it would serve to allay fears of misuse of the warrants for less serious crimes and perceptions of legislative creep. I took you to be referring to give some examples that we've already discussed this morning, things like trademark infringement or an allegation of bigamy, which would, as the legislation is presently drafted, be captured. Is that what you were getting at?
Yes, Mr Dreyfus, that is. I think it would be helpful if there were clear offences that were not in consideration I'm obviously not an expert in whether they would ever be considered, but it would strike me that to allay concerns that it could be used for a far wider net, classes of offences should be defined.
Thank you. And if I can come back to the data disruption warrants, in his recent review of national security legislation, Dennis Richardson, former head of ASIO and former head of defence and former ambassador to the US, Mr. Richardson recommended against the conferral of a specific cyber disruption power on law enforcement agencies. What he said was that a power like the one that's being proposed in this bill, which would allow law enforcement to cause material loss or damage to potentially large numbers of lawful computer users, would place the AFP and the ACIC, as he put it, in the position of judge, jury and executioner. That's a quote from his report. Has the Centre read the Dennis Richardson report, and in particular Chapter 38, which argues that a new disruption power for the AFP is not needed and for both practical and principled reasons not desirable?
I've read parts of the report, not specifically the chapter you're referring to, and obviously respectfully that is his view. My understanding of the warrant as it's currently set out in the bill is that it does not seek to destroy or innocent material, and certainly doesn't want to zap a computer as per the EM and as drafted. And whilst I note Mr. Richardson's perspectives, I can also see the case where a data disruption warrant is necessary in the event that there is live activity going on. The site is, well, say, a site for illegal drugs or child exploitation material is necessarily going on and causing great harm, that there could be a case for such a warrant in place. I think as currently drafted in the bill, not the Richardson report, they do have specific examples of how it could be used, and it's only to be used where they can't use other warrants or have other means of disruption or intelligence gathering. But I could imagine certain scenarios where it's an effective warrant and an effective power, noting it's not a power to destroy evidence.
But it is a power that can be used to damage and potentially cause material loss to large numbers of lawful computer users. Do you accept that?
I'm not sure I accept that respectfully, only because lawful computer users could necessarily be caught by the activities at the time. How I've seen the examples would be more disruption of, say, we'll use a dark web or a market bazaar, a drug market bazaar, that suddenly if you're on there, you won't be able to make payment or you won't be able to affect your sale, I assume. It's like a DDoS, suddenly it just doesn't work, and I think there are examples of that in the States where people have gone to use it and it just is down, everything's down, people can't access things. I don't know whether that's necessarily a detriment or damage that the potential purchaser suffers, also engaging in a criminal activity, whether they suffer any damage to their computer. They certainly suffer damage, if you like, to their prospective drug purchase. But I don't understand it to mean it extends out to causing damage. My understanding is that it extends out to disrupting what is going on at that time.
Which has got the capacity to cause material loss or damage to computer users.
Well, I can't think of a scenario where if the warrant is drafted tightly as intended, the people or the users who were affected or impacted potentially are involved, obviously potentially in criminal activity. But I'm using the dark web kind of drug market bazaar scenario. But again, my understanding of it, it's not intended to cause permanent damage or damage to computer users in a permanent sense. And one would hope that when drafted and the activities, that they don't do that. It's not intended. It's intended to disrupt an potentially illegal activity going on at that time.
In any event, I'm a bit hesitant to take this up with you if you haven't read the particular part of Mr. Richardson's report. And
Sure.
Did I understand you to say that before?
Yes, that's correct.
At page 9, of your submission, you've written about the definition of criminal network of individuals, saying that you think it's fit for purpose. Did you hear the evidence of the Human Rights Law Centre and the Law Council on this point?
I didn't hear that.
They gave evidence this morning.
Yes, no, I didn't hear that. Did you hear that?
I did hear that.
I'll do my best to paraphrase it. In essence, they were saying that the definition's so broad that it could mean that where a person is suspected of engaging in a relevant offence, every other user of any website they access or app that is installed on their phone could potentially have their data accessed, changed or deleted without their knowledge, consent or opportunity to object. Given that that's the view they've taken, that's the Law Council and the Human Rights Law Centre, of the definition of criminal network of individuals, would you maintain your position that the definition of criminal network of individuals is appropriate?
Certainly. The AFP and the ACIC have finite resources, and we would respectfully submit that such an interpretation is essentially unreasonable and, more to the point, unfeasible, given the limited resources. For example, the example that was given by the Human Rights Law Centre in relation to every member of WhatsApp being captured. Well, that's ludicrous.
Well, are you saying it's ludicrous as a matter of legal interpretation, or you're saying that the AFP would not wish to access the data of every user of WhatsApp?
In practice, it would be completely unfeasible.
No, well, let's be clear about this. Your proposition is about, it's some kind of proposition about the way in which the AFP would seek to investigate. You're not putting forward a contrary view about the way that the the legislation should be interpreted.
No, it could certainly be interpreted in that manner, but to do so is unfeasible in my opinion.
In what sense unfeasible?
Because of the finite resources of the AFP and the ACIC.
But I'm trying to get at what you're saying to the committee here. If I've understood you correctly, you accept that the legislation as interpreted by the Law Council of Australia and the Human Rights Law Centre is correct.
Yes, we're not arguing with the legal interpretation.
You're putting some other proposition to us that says that it wouldn't be used in that way. Have I got that right?
That wouldn't be proportionate.
Sorry, what wouldn't be proportionate?
The application of such powers to every user of such a service, it wouldn't be proportionate.
Proportionate to what? I'm really not following what you're trying to tell the committee.
So, Mr Dreyfus, with respect, I would submit that whilst it could be a significant number of WhatsApp or a group on WhatsApp, it wouldn't be proportionate, and I would imagine, and imagine's the word I want to use, that in the drafting of the warrant, you would need to say, define the network in some way, and it could be, we believe there are 150 users of this WhatsApp network or 150 users of these groups, but to suggest that, and I couldn't imagine that it would be proportionate or meet any sort of test to suggest that we want to now we define, the ACIC or AFP would define a network of criminal network of individuals as all WhatsApp users, would just strike me as probably something that would not be authorised. Well, one would hope.
But we don't generally draft legislation on a hope, I've got to say to you. Wouldn't it be better to have clarity in the legislation that restricts the definition of criminal network of individuals to ensure that what's sought and the power that's given, these extraordinary powers that are given by this legislation, is in fact limited to criminals?
Well, yes, Mr Dreyfus, that is a good point. point, one could tighten the drafting so it's, and I think they've tried to do that with knowingly or unknowingly, and the individuals, there is a looseness about it, but one could certainly have the reasonable suspicion or the reasonable sort of intent in there in the drafting that it is the belief that these users, at least this core group of users in WhatsApp, are intending to commit offence or intending, or the relevant legal test. But at the same time, I think they also don't know until they get in there, so to speak, who's linked to who, hence the request for the extension of these powers into the digital world, because I'm sure, like crimes in the real world, they don't always know who is connected to whom. But, and I appreciate your point, legislation should never be drafted on a hope. It gives none of us any comfort, particularly users of WhatsApp. But the regime, hopefully, and I say hopefully, regime in authorisation should allow the authoriser and the magistrate to be able to sign off with some degree of particularity about what group is known and what group are the criminals or potential criminals in the criminal network of individuals.
Mr Dreyfus, I just want to clarify if other committee members have questions for these witnesses, because we are getting close to the end of their scheduled time. If other committee members could indicate to me either directly or through the video system. Senator Fawcett, is that you indicating?
Yeah, James, I just wanted to actually ask a follow-up directly on this point, and I think the witness was just going to it in extending Mr Dreyfus's line of questioning. What do you see the role of the approving authority being in determining what is a reasonable application of the law versus something that is an unintended application of the law? Could you perhaps continue with what you're presenting then as to the role of the approving authority, which I think is quite critical, given that that's a common feature of each of these three tranches?
Absolutely, I agree. I think the approving authority in each three cases needs to always, and I'm sure they do, cast a critical eye on what's being asked of them, the intended targets, why the nature of this warrant, and what the reasonable belief of the requesting authority, the law enforcement agency or ACIC, is. They play a key role to be effectively the gatekeeper and the authorising officer. So, to Mr Dreyfus's point, I would expect that if in the warrant application it said all of WhatsApp users, that authority would say, excuse me, there are millions of users, what could possibly be achieved like that? I'd like you to walk me through, and I want to be satisfied that in any way that group is, the whole group of WhatsApp users in the millions would form a criminal network of individuals, and it just couldn't, in my view, any reasonable authority couldn't sign off on that unless we're all in trouble then, and unlikely.
I think that it's also really important to use to note that, given that these are extraordinary powers, which we readily accept, that there is a history within the authorised, in terms of the authorisation of these warrants, of them actually, or other extraordinary warrants, of them being administered discreetly. I think TOLA is a really great example. Last year, the committee heard from the AFP, who noted that since TOLA commenced, and these figures are obviously out of date now, but at that point 8 technical assistance requests had been issued, 16 computer access warrants and 23 TANs. So that is really obviously goes to the heart of this, where these aren't powers that are being applied willy-nilly. They are extraordinary powers, and they are being applied in a proportionate and appropriate manner.
Okay, I'll go to the Deputy Chair and then return to Mr Dreyfus for any remaining time.
Thank you, Chair. Although I would say that was a very similar argument that we heard to mandatory data retention, where we specified that a subset of information would be held by telcos and would only be accessed by, I think it was 20 prescribed entities. What happened was that legislation was passed, but then a loophole was found. So we still have the RSPCA and local councils using people's metadata for accessing, or they're accessing metadata off the basis of someone not paying a parking fine, which is outrageous and ridiculous, and it compromises the security effort. So I think that's where Mr Dreyfus is coming from, that we know what the intent of the legislation is, but how it is written and then how it could be executed could be two different things. But my question is, could you tell me of the comparable jurisdictions, the Metropolitan Police, the FBI, do they have these same powers?
I'd have to take that on notice, but I'm happy to do that.
Yeah, because I think if you could please,
Yep.
Because I think it would offer some form of illumination and comfort to committee members if we knew that there are other overseas jurisdictions that were like our ACIC that had similar powers, that we might not be going down the sort of like the pathway of having powers that other comparable agencies in similar jurisdictions don't have. But if you could take that on notice, I would appreciate that. And thank you, Chair.
Thank you, Deputy Chair. Mr Dreyfus, we can go for a couple more minutes if you have further questions. If not, in that case, I'd thank you very much.
Sorry. I
Oh.
was on mute.
That's okay.
Chair, sorry, I was talking to myself on mute. I did use the time to go back and have a look at the bill, and this is taking you back to the question of the data disruption warrant. The proposed new section 27KE7 of the Surveillance Devices Act, which is what this bill amends, explicitly entertains the idea of a data disruption warrant authorising the deletion or alteration of data or doing a range of other things that is likely to interfere with, interrupt or disrupt the lawful use of a computer by any person, provided it's necessary to do one of the things specified in the warrant. So if I could just make this concrete by reference to a hypothetical example. In order to disrupt data that's covered by a warrant and which is held in a large telecommunications facility, and that's specifically envisaged by section 27KE2C6, it might be necessary for the AFP to disrupt all data held in that large telecommunications facility. And that might be because it's not technically feasible to single out the relevant data for disruption. So, coming to my question, under a disruption warrant, the AFP or the ACIC could be authorised to undertake that activity to disrupt all data held in a large telecommunication facility, even if that would interfere with the lawful use of that facility by potentially thousands of people who are not suspected of any wrongdoing. Have I got that right?
I won't challenge you there, Mr Dreyfus. It could well be the case, and in which case you would hope that the tools used and the warrants would be applied with forensic precision so that that outcome you've mentioned was avoided, because absolutely that would be a nightmare for the innocent bystander, so to speak, the normal users, the company that owns the data, and there's a whole bunch of third-party sort of damages and consequences that flow. But I would like to think then there's forensic precision, and maybe that is something that needs to be built into the bill around the use of that warrant particularly, and the targeted data that they seek to disrupt or alter.
Well, I'm sure we'd all share that hope, but it does seem clear to me that under a data disruption warrant, as the bill is presently drafted, the AFP or the ACIC could be authorised to cause material loss or damage to large numbers of computer users who would include individuals not suspected of any wrongdoing. And I take it you don't seek to argue with that.
Well, I don't have the drafting in front of me. I won't challenge you on that front. But again, could not some form of drafting be included then in the bill that requires them to absolutely minimise any disruption to third parties that are not the subject of the warrant, and to in some way forensically compel it, that they have forensic precision. Obviously, the drafting to be worked out by people who are expert in drafting legislation, that is absolutely targeted, which I imagine they would do, targeted to cause to the targets only and to cause minimal loss to third parties, which in the real world I would imagine is the same thing. They don't want to bash down doors of the neighbours and the neighbours of the neighbours. If they're targeting one meth house, they want to keep it targeted and precision-like.
Well, just to finish off this point, you seem before to be setting quite a lot of store on the possibility that the person issuing the warrant might ask appropriate penetrating questions, but I wanted to point out that the Law Council notes in its submission that a data disruption warrant could be issued by an ordinary member of the Administrative Appeals Tribunal nominated by the Attorney-General who is an admitted lawyer of only 5 years standing, which could mean someone that had never practiced law following admission. Do you think that your hope that the issuing authority, if it's someone in that category, that is, someone who's been out in, has had their practicing certificate for 5 years only, might have had no experience of anything in the world, perhaps has been working in a field other than the law and knows nothing about cybersecurity, do you think it's that would be an appropriate person to be issuing a warrant of this nature, a data disruption warrant?
Mr Dreyfus, absolutely not. You always want someone who has had experience as a legal practitioner for longer than that, although I would respectfully submit there are members of the bench who don't necessarily understand cybersecurity or how things work technically, but I would certainly want someone who understands the gravity of what they're signing, and that could be a legal, if not a legal practitioner of more than 5 years, but somebody on the bench, but somebody who is sufficiently also equipped with the knowledge to understand how these warrants operate and the technical nature of the warrant. So I would agree with you, it's a good point that you always want the issuing authorities to A, understand the technical nature of their operation, and B, the potential unintended consequences and the impact on targets or other people that should or should not be caught. So I would agree with you that possibly 5 years and having worked maybe in a city law firm is not enough.
And given the time, we're going to have to wrap the conversation up here, but I'll just ask a final clarifying question on this point. The Law Council has explicitly said that an AAT member or a magistrate is not sufficiently senior to be approving these warrants, and it should be elevated to a judicial appointee. Would you have any objections to that, and can you foresee any operational issues that would cause if that were to be the case?
No, I don't object to that. I think my understanding is to be a magistrate, you need to be admitted for 7 years or longer. But no, I would not have if that gave a greater sense of comfort, then it should be a judicial officer.
Okay. Well, thank you very much for your attendance and your evidence before the committee. It's gratefully appreciated. We may submit further questions on notice to you after this hearing. I'll be grateful for your cooperation with that. You'll also be sent a copy of the transcript, so if you have any corrections to that, we invite you to make those. The committee will now be moving to the Communications Alliance.
Thank you very much, Mr Chairman. This is John Stanton, the CEO of Communications Alliance. I have appearing with me today Christiana Gillespie-Jones and also Patrick Fair, who is the chair of our Communications Security Reference Panel.
Thank you. And just for the Hansard record, could I ask that they introduce themselves as well?
Good afternoon. My name is Christiana Gillespie-Jones, Director of Program Management at Communications Alliance.
Good afternoon. I'm Patrick Fair, Chair of the Communications Security Reference Panel at Communications Alliance. Okay.
I now invite you to make a short opening statement, after which the committee will proceed to discussion.
Thank you, Chair. If I may, I'll just briefly summarise the key points in the submission that we made to the committee. The first is in relation to what we see as the need for consultation with communication service providers before warrants are issued. It's clear we believe that these three types of warrants are potentially very far-reaching and consequential, and we would suggest that the bill be amended to provide that the service provider who would be required to action a warrant or assist with or facilitate its execution ought to be consulted prior to it being issued, not least because doing so would not necessarily slow down the process, but may indeed help to target the warrant in a way that would have, we would tend to help avoid some of the unintended consequences, examples of which were raised in the most recent testimony before the committee. Secondly, and this is a point that's just been tracked over, so I won't dwell on it, but we would certainly agree that the authorisation of data disruption and network activity warrants ought to be by an eligible judge, not a member of the Administrative Appeals Tribunal. Next, we would be strongly supportive of the bill, including provisions that could provide for independent technical advice to be given to those parties seeking to issue warrants to try to, again, ensure against unintended consequences. This is the sort of approach taken under the Investigative Powers Commission in the UK. And it's a need that was very strongly endorsed by the Independent National Security Legislation Monitor as part of his report concerning the TOLA legislation. Next, and this is, I think, already thematic in some of the evidence and submissions you received, we would support also a higher threshold of offence to make a warrant able to be issued, moving to not just an offence that it could attract a 3-year sentence, but rather a serious offence in line with the thresholds that are in the Interception and Access Act. We believe that the criteria for applying network activity warrants is too low as well. The only real requirement is that a network activity warrant has to be relevant to the prevention.
Sorry, Mr. Stanton, I didn't want to interrupt, but there is some real background noise. I'm not sure if it's a committee member or a witness, but anyone who's not speaking, could you please mute yourself, because it's going to be very difficult for Hansard to transcribe if there's cross-talk.
Yes, it's not at my end, Mr. Chairman.
I don't want to embarrass any committee members, but it sounds to me like it might be a committee member. And so committee members or perhaps their staff who are within earshot could assist by ensuring all committee members' phones are muted. That sounds like an improvement. Mr. Stanton, please continue, although please be brief because we do have a number of follow-up questions.
Thank you, Chair. The next point I was going to make related to the criteria for applying network activity warrants. And at the moment, the only real requirement is that a network activity warrant has to be relevant to the prevention, detection or frustration of one or more of the kinds of relevant offences. And that's a very broad series of set of offences indeed. We would suggest that the threshold for this warrant be amended so that it would need to relate to a reasonable suspicion that a serious offence has been or is likely to be committed. Next to last is the question I think that was raised in earlier discussion by committee members, and that's the privacy of third-party data. Obviously, privacy is a very serious issue for communication service providers, and they take the responsibility to protect customers' privacy very seriously indeed. There is a real risk, we believe, that the privacy of the data of third parties could be compromised when they are not the subject of an account takeover warrant. And we think that the relevant provisions of the bill ought to include protections for information that's being accessed in the course of such action, but is not related to the crime under investigation. And my final point, Mr. Chairman, relates to assistance orders in the proposed new sections 64A and 64B of the amended Act, which would allow law enforcement agencies to compel specified persons to provide reasonable information and assistance to agencies. Those sorts of requests could well go to communications platform providers, And it would seem to us more appropriate that the target of those requests ought to be the relevant customer or user of the platform rather than the platform itself. I'll pause there, if I may, Mr. Chairman, and we're happy to try and field any questions that the committee may have.
Thank you, Mr. Stanton. And just before I commence with a couple of questions, I just wanted to note for the record that 3 companies who I believe are members of the Communications Alliance, and please correct me if I'm wrong, Telstra, Amazon Web Services and Twitter, each made submissions to the inquiry and as a result were invited to appear as witnesses, but were either unavailable or declined to do so. I just want to state for the record that we really welcome the participation of the companies themselves in the inquiry process, and we are very grateful for their submissions because as the people who may be at the coalface of actually implementing or applying these laws, their insights are really helpful. So while we're delighted to have the Communications Alliance appear, I just want to place on the record in the future we may require the assistance of those companies more directly before the committee to answer questions.
Thank you, Mr. Chairman. We will certainly provide appropriate encouragement in those circumstances.
Thank you. Moving on to a couple of questions. I won't dwell on the themes that you've raised which are consistent with other witnesses, for example, the issue of relevant offences or that a judicial officer be required to provide authorisation, because you don't have different views on those and they do appear consistent. One interesting recommendation that you've made is that the service providers themselves be given notice before a warrant is issued. I can understand why, from the perspective of your members, that might be desirable, but I can also foresee potential problems with doing that, and particularly with some service providers. I'm sure all of your service providers are upstanding corporate citizens and would behave appropriately, but it is foreseeable that not all service providers in this space might appropriately handle early notice of something like that. Can you foresee those issues?
Not as clearly as you, Mr. Chairman. I mean, this is a very heavily regulated sector with a culture of compliance and a long history of working productively with agencies. And certainly in the case of Communications Alliance members, our suggestion is designed to help. If you go back not too far in history, some may recall the website blocking order that was put in place by ASIC, which resulted in massive over-blocking and overreach and the disruption of some thousands of legitimate accounts. And had there been this sort of cooperation and targeting beforehand with those who are at the coalface, as you put it, and who have the technical expertise, that could have been avoided. I can't particularly think of any player in Australia who would not respond positively to that sort of request from agencies, because at the end of the day, it's in the interest of their customers as well as in the interests of the objectives of the agency involved.
Yeah, well, as I said, I wasn't really directing it at your members, but I mean, we've heard evidence in this inquiry and has been evidence before the committee in other inquiries that there are some service providers who explicitly market their encryption as a way to hide things from law enforcement agencies. Surely you can anticipate why there might be some reticence about giving a company like that a heads up that a warrant was being sought to one of their users.
Look, I take your point, Mr. Chairman, but I would say that agencies have a very good knowledge of which players are good players in the marketplace, those they work with under the TSSR regime, for example, and under TOLA, and so they would be capable of making a judgment about whether there is an undue risk of a bad player behaving badly. But
so just to clarify then, rather than it be a requirement in the legislation that a service provider must be notified, you're saying it should be left to the discretion of the agencies whether or not that's appropriate?
Could I say something about this, Mr. Chairman?
Please.
It's Patrick Fair speaking. The primary issue here is that the test for these orders is reasonableness and proportionality. and that test can't really be understood in a vacuum. It's not as if the technology that could be the subject of these orders is some kind of generic average technology, as if you were dealing with web blocking, for example, or standard telecommunications. You're talking about a specific implementation of specific proprietary services that may be operating at scale in the cloud or may be operating in other ways. And it strikes me anyway that the legislation is just profoundly undercooked in terms of taking a 19th century approach to the formulation of law around warrants, as if a person is probably going to be an individual and the target is going to be something that can easily be done. It needs a much more sophisticated touch where, in order for the relevant legal officer to make the determination that's being asked for, they're properly informed about the system that's the target of the warrant and the steps that might need to be taken in relation to that system in order to implement the change. What's needed here is a distinction between, the target being somebody who's suspected of bad conduct, the target who needs to be urged to cooperate under legal order, and a passive target that's prepared to assist to work with law enforcement, where information needs to be collected and presented to the party making the warrant before the warrant's issued, so that the reasonableness and proportionality of the orders that are being sought can be properly assessed. And so this question of consultation goes to all of those questions. And I think another relevant thing, if I may, is I was listening to the earlier discussion about the use of 5-year lawyers appointed to the AAT to make these determinations. Of course, this legislation doesn't just amend the Surveillance Devices Act. The account takeover warrant is an amendment to the Criminal Code, and the proposal is that ordinary magistrates be issuing these orders. And when you read the powers in section that are allocated in accordance with that, look at 3ZZUR of the account takeover warrants, to be making those orders without consulting with the target provider is extraordinary.
Okay, thank you. I have one further matter I want to ask about, and then I'll offer the call to other committee members. A number of submitters have raised issues of potential extraterritorial legal issues with data being stored offshore, even for Australian service providers. Could you just elucidate the concerns of your members about those issues?
Yes, I can do so. Sorry, it's Christiana Gillespie-Jones from Communications Alliance. The bill includes provisions that the bill finds extraterritorial application for all 3 warrants, and it's specifically for the account takeover warrant. It does not seem to find. It does not seem to see any consent is required from an official or the service provider that has to be sought. That stands in contrast to the data disruption or network activity warrant, which do require that access has been granted by an appropriate consenting official in the foreign country. So it seems that this creates, or could potentially create, or maybe even likely to create problems with friction with other foreign legislation, where such access to accounts might be sought, and this infringes upon legislation in other jurisdictions.
Okay, thank you.
And Mr. Chairman, if it's John Stanton here, if I may, I just return to your earlier question with a suggestion. Maybe a compromise path in terms of consultation is that the default path ought to be that service providers are consulted unless the agency has a reasonably held suspicion that the service provider it is planning to hit with the warrant would not act in good faith.
Thank you. Noted and appreciated. Mr. Dreyfus, Mr. Byrne or Ms. Ali, can I offer you the call?
I've got a question. Mr. Stanton, could I ask whether your members have raised with you any commercial concerns about this bill?
I think that one of the things that is in mind is the question of whether disrupting data by its very nature has the potential to create difficulties for the international partner relationships that they rely on to receive, to send, and to transit data, content, and voice traffic around the world. I'll just ask Christiana or Patrick whether you've had other examples.
Not quite a commercial issue, although you might characterise it as that. There's serious concern regarding 64B and the other matching amendments which extend the ATOLA power to authorise people to assist in the implementation of a warrant. When you think of the warrant subject matter and in fact its existence being subject to protected information status and so that it cannot be talked about and communicated, there's quite some concern that ordinary employees within service providers could be required to assist with the implementation of a warrant and be placed in a very difficult position where they need to think about their employment obligations, get legal advice as to whether or not they can do what they're being asked to do, and if they do so, whether that might have adverse consequences to them within the organisation. So there's quite a concern about the extension of the powers, which mirrors this concern that was also expressed with the ATOLA legislation.
That's an interesting concern that you've raised. It's not something that's spelled out, as I understood your submission. Is it, just to pursue that, is it possible to conceive of a way that the bill could be altered that would take account of that concern?
I think the suggestion I made in my earlier comments that there really should be a distinction between corporate targets who are technology providers and someone who might be thought as a potential bad actor, and a sort of a way of managing the information collection and deployment of the warrant cooperatively with the technical service provider, rather than treating it like you were searching a house in old times. A more sophisticated approach like that could take into account the fact that you would need assistance and cooperation to implement the changes you want to make in a way that's consistent with the technology that's the subject of the warrant. And,
and that's to go back to the very first point made in your submission, that there ought to be a requirement for consultation with service providers.
Exactly. And consultation, implies, I think, cooperation in the implementation. You'd find the right person who could assist, and you'd work out how to do that consistent with the corporation's internal requirements and reporting obligations. But also, minimise the risk of collateral damage resulting from the implementation of the warrant.
And as all three of you have said, there's a long history of cooperation between agencies, police and service providers in Australia. You're seeking to have that built on with an express reference in this bill.
That's right.
Thanks very much, Chair.
Thank you. Other committee members? Senator Fawcett? No? Sorry, Ms Ali. Yes, you're indicating.
Thank you, Chair. I just wanted to pursue the line of questioning here and not so much go to the things that you've raised about the bill itself, but about some of the recommendations and suggestions that you made specifically around consultation. But you've also recommended independent technical advice as well. And in your submission, you suggest that the investigative power approach suggested by the Insulam would be appropriate for that. And I wanted to take that back to the Chair's point about some service providers who actually market encryption as to their customers and attract customers through that marketing of encryption as a way to basically circumvent security and law enforcement. And I wonder if you could talk a little bit more. I just need a little bit more clarity on how consultation and independent technical advice would address that issue.
I think it's fair to say that what people might want to say to their customers as to the technologies they deploy in their system and what they will say to law enforcement when approached to assist with the prevention or the detection of a serious offence is not the same. And although in my experience, there are certainly providers who sell encryption tools and say this is secure and this is what it does, and there are also customers who aren't engaged in major crime who, through their civil priorities, decide they'd rather not be watched by the government or don't want their data collected for marketing purposes or for some other reason. So it doesn't follow that because secure services are offered to the public, they're necessarily not going to cooperate with law enforcement and not going to assist in implementing lawful authorities. In fact, in my experience, it's quite common for international providers to voluntarily accept service of warrants which they may not need to cooperate with because they are offshore in order to be a good citizen and cooperate with law enforcement. So I think that I'm sure there are cases where there are bad actors who won't cooperate, but I don't think it flows from the fact that they're offering a secure service to their customers that they will necessarily be bad actors and or not cooperate.
And the other point, John Stanton here, the other point, I guess, is that the provision of independent technical advice as is in place in the UK does provide the agencies with, and those issuing warrants with a much better idea of what the art of the possible is, and whether in fact any difficulty that's encountered in accessing information or network features is a result of bad intent or non-cooperation, or whether it's simply a function of the technology. And as Patrick said, there's a long history of good actors that promote the security of their services. Way back when BlackBerry devices were marketed very heavily because they were more secure in their communications than the other handsets of the time, and that was attractive for legitimate purposes for business customers around the world.
So if I can clarify, your recommendation about consultation and independent technical advice really harks back to that comment that you made earlier about the laws being kind of, I guess, 19th, I think it was that you said 19th century laws dealing with the 21st century infrastructure. Would that be a correct way to put it?
Yes.
Thank you. Thank you for clarifying that, and thank you, Chair.
Thanks, Ms. Ali. Deputy Chair, do you have questions? I have some more to proceed with, but I'll defer to you first if you wish.
Thank you, Chair. Just one or two.
Please.
John, in particular, I was just wondering, are you aware of, I asked this question of the Cyber Security Resource Centre. In your dealings with your counterparts overseas, are you aware of whether or not the Metropolitan Police or the FBI have this power that the AFP and the ACIC are seeking?
Personally, I'm not. I think it's a very good question, and I wish I had the answer for you. I could take that on notice if that would be helpful.
If you could, yeah. And just in generally, I think you mentioned about the Independent Investigatory Powers Commissioner. Do you think, given the raft of changes that are being made in the telecommunications surveillance device area, that there is a need for a separate commissioner, aside from IGIS and the Commonwealth Ombudsman and the Privacy Commissioner?
Yes, we were very supportive of the notion that the Insulin explored and the way that the system operates in the UK. We think it's been successful. It results in suitably legally qualified people with suitable technical independent advice by their side, making probably better decisions than we may at times see within the Australian framework. So we were supportive in relation to TOLA and the Insulin's report in relation to the review of that legislation, and equally so in the case of these proposed amendments.
Did you want to quickly just elaborate for a lot of people that may be listening that don't know the powers of the Independent Investigatory Commissioner, what they might be, just in a fairly quick nutshell? Because I think it's useful. I'm actually quite attracted to the proposition, just for your information, and I've been following your submissions on these issues for some period of time, but it might be useful for the broader public to get an understanding of what happens in the United Kingdom.
Well, at a high level, there is an independent commission that's been established. It is staffed by suitably qualified, typically retired judges, and thus with a lot of experience and a fairly independent view of the world. And they are assisted by a panel of independent technical experts that can be brought in to furnish them with good advice about the art of the possible, about the risks of overreach or unintended consequences associated with the request for warrants that they receive from the UK agencies. And so it's a pretty good triage system that sorts through and helps to detect warrant requests that are not well based or that don't actually reflect the intention of the agency involved. And in our view, and I think in the view of the Insulin, it results in a better, more targeted process with fewer unintended consequences, and it tends to operate pretty speedily, perhaps more quickly, for example, than may be possible through the Administrative Appeals Tribunal.
Yeah. So you would be saying that this could be the sort of the paradigm or the new paradigm or the new system that we could employ, given some of the sort of the increased number of intrusive powers that have been given to agencies like ASIO, and in this instance like the AFP and the ACIC.
Indeed, and in fact, it would be beneficial, we think, not just for the individuals affected by warrants, nor and the service providers having to assist in their execution. It actually points towards better outcomes for agencies, and them getting better service, in their requests being better targeted, and therefore generating better investigative outcomes for the agencies themselves.
Yeah, and I thank you for that. No, that's all I wanted to ask Mr. Stanhope. And again, as always, and particularly I've dealt with you since the initial data retention inquiry, thank you for your constructive evidence on an ongoing basis on these matters. Thank you.
It's a pleasure. Thank you.
Thank you, Deputy Chair. I've just got two final matters that I'd like to pursue with you, and then I'll invite any final questions from any other committee members. The first is just, could you expand a little bit more on this issue of the most appropriate place to direct assistance orders, the business user or the platform provider rather than an individual officer or an employee? Could you just explain why that's important and what change you're seeking?
Yes, I can take that. Or Patrick, do you want to take this?
Sure. No, I'll leave it to you, Christiane.
Okay. As as we understand it currently, the legislation in the section 64A and 64B, the new sections, allow enforcement agencies to compel so-called specified persons to provide reasonable information and assistance to agencies aimed at the execution of a warrant. The problem is that specified persons is not clarified or defined in the bill itself or anywhere else. I don't think if I remember correctly, the explanatory memorandum provides further assistance either on this matter. Therefore, it is possible that it could equally be directed at any employee of for example, cloud service provider. Now, we have two issues with that matter. For one, we believe that such a request would be more appropriately directed at, for example, the customer of such a cloud services provider, the business customer typically, rather than the intermediary who just provides the infrastructure for that service.
And sorry to interrupt, Ms. Gillespie-Jones, but just for the plain-speaking, non-technical, who would that? Give me an example of who that customer would be, rather than the intermediary.
So if we're talking about a large data storage service provider who enables all sorts of business services, that is the intermediary. And then you have a business customer who actually uses that storage and provides a business service to end users and sells maybe some online products. Yep. And uses that business service.
And just for devil's advocacy here, can you foresee a circumstance where it might be more appropriate to direct it to the server business rather than the end user, because perhaps the end user is the target?
You mean the end user or the business user?
It could be a business it could be the business which is of interest for the investigation.
We would assume that typically it's best directed to the business user, as opposed to the intermediary.
And you think that's the case in all instances?
No, and I was about to come to that. If it must be directed to the cloud service provider, then we would like it that the law clarifies that it's not be directed or cannot be directed to just any employee of the cloud services provider, who then may not be able to communicate about having received that request for assistance, and might be struggling with the terms of its employment contract, depending on what is asked or what is being asked of him to do. And we would like that this request, that is clarified, that this request be directed at the organisation itself.
I think, can I just add to that it's it's a very conventional approach. Particularly, there's guidance. I believe the FBI has guidance to this effect, that if you're seeking a warrant from, seeking a warrant for access to information, you should default to ask the party whose system provides the service of storing the information, and only, in extraordinary circumstances should you be going to the infrastructure provider or an interim third party, because, well, first of all, the degree of difficulty is much magnified, because possibly the infrastructure keeps everything encrypted anyway, and only the party who's actually using the service at the far end has easy access to the content that's needed. But also, issues arise that if you sort of start to not deal with the party that's managing the service, then the service, when they detect anomalies or things that are happening, they can shut down access, or reset or close, or perhaps undermine the orders that are given. So from just a logical point of view, it's a far more sensible methodology to focus on the party that's actually providing the service and gain their cooperation, rather than targeting warrants to point to the infrastructure on the hope that you won't be noticed or found out, or it'll add to some sort of have some other benefit.
Okay, so just for clarity, it's kind of two concerns you have. First is it should not be aimed at intermediaries, it should be aimed at business users. And secondly, it should be aimed at corporate entities, not individual employees within that business user.
Correct.
Okay, thank you. Moving on to the final matter from me, I understand you've got concerns about the privacy implications of an account takeover warrant and that potentially third parties associated with that account takeover warrant, their privacy could be compromised who are not of interest to an investigation. What safeguards, firstly, if you'd like to outline your concerns about that, but secondly, what are the appropriate safeguards that you think should be implemented to protect against that?
Well, I think go on, John.
No, go ahead, Patrick.
I was going to say that the legislation does have some a framework in it for protecting information which is obtained using the warrants, and but it doesn't focus on the ancillary exposure of information that might be unrelated. And in particular, when you look at something like an account takeover warrant, where essentially, this is garnering to the benefit of the enforcement agency whatever might happen to be in that account, which could be old correspondence, document, email, other things, which are, it's the idea of an account takeover warrant itself is highly privacy intrusive. And our suggestion is that the privacy implications of the very broad brush nature of the power should be taken into account before the warrant's issued.
I think the related point goes back to this question of consultation, because if there is appropriate discussion about targeting between the agency and the service provider in question, then it may be that would make it less likely that the data of third-party providers would be either made less secure, which can happen if there's moves to disable the existing security features, or blocked or disabled, as per the example that was discussed by Mr. Dreyfus earlier about large numbers of unrelated customers' data being potentially blocked or interrupted if they happen to be in the same facility where the warrant is targeted. So again, if we have a requirement for that type of consultation, we start to hopefully reduce the risk of these sorts of unintended consequences, and the risk that making changes to data or to accounts or to networks or any of the other components that are possible under this legislation would in itself create vulnerabilities and open the way for cyber threats that could affect not just the account in question, but potentially millions of others.
Yeah, and I just want to be really clear though, Mr. Stanton, because your answer blurred a little bit the three different categories of warrants there. I'm specifically interested in the account takeover warrant, and to give it a more specific example, a warrant is granted to take over the account of a WhatsApp user, and on that WhatsApp user, they have illegal content which is of interest to law enforcement, but also irrelevant content. I'm just trying to understand what additional safeguards you're proposing to protect that irrelevant content or those innocent users that just happen to have a WhatsApp connection with that person who also is engaging in unlawful behaviour.
Thank you. I must say I don't have a simple solution there, but we do believe there ought to be additional protections. We would be very willing to, with our members, engage with agencies around what sorts of solutions and protections would be appropriate in a way that it's not really possible to try and develop during today's hearing.
Sure, and what I might do then in that is, Mr. Stanton, is ask you to take that on notice and come back to the committee, because your engagement with agencies on this matter would be the end point after the legislation is passed and they'd be empowered to do it. Your engagement with the committee comes before that, and we've got an opportunity to shape the legislation. So if you do have any concrete suggestions that you think could be incorporated by way of a recommendation, we would welcome that on notice.
Thanks. I'll certainly take that on notice and try to come back to the committee.
Great, thank you.
On that point, if I may, it's Christiana Glester-Jones. The account takeover notice does require taking into account the privacy of third party. In addition, we have a concern that the network activity warrants, which can equally be damaging for the privacy of third parties, do not have a requirement to take into account the privacy of third parties. So that is a concern that we have raised in our submission too. We would like to see that irrespective of whichever warrant is being issued, the privacy of third parties has to be taken into account prior to issuing that warrant.
Okay, thank you. Can I just see if any other committee members have further questions for the Communications Alliance? Senator Fawcett, I see you leaning forward there.
Yes, just to follow up on that last point, previous witnesses have highlighted that whilst privacy is a key concern, that other bodies, for example, of the United Nations, have also highlighted the obligation on nation states to give law enforcement authorities effective powers to combat things like child exploitation. In your view, does this bill do that? Does it give them effective powers? And what is the role of the issuing authority to find that balance between effective powers and privacy? And are there specific things that you think need to be changed in the bill that would inform that issuing authority or better guide them in finding that balance?
I think that question goes to the sort of point we were making earlier about the need for the issuing process to be made in a environment where the information about the system that's the target and the relevant subject matter is better known to the issuing officer, and by that mechanism, helping to make by that mechanism and supporting technical advice, helping to make sure that the warrant is properly targeted to the mission of the law enforcement agency, and therefore, quickly made, effectively implemented and properly enforced. So, in a way, the submissions that we've been making about the need to recognise that you'll be dealing with very sophisticated corporate entities with layers of controls and systems, the need to engage with them as to what's required and what's needed, and the need to focus the warrant on that. And particularly by focusing the warrant, you can help protect the privacy of people by not accidentally exposing unnecessary accounts or information. So I think that's how we would answer that question.
So
if I may add to that also,
the AFP, and if you look at the example number 2 in the AFP submission, where they talk about a child exploitation case, the dark web, in that situation, who are the corporates that you are concerned about?
I don't think it's our submission that the concerns we express would apply in every case. And in fact, you can read the legislation as if you're targeting the laptop of a gang member who's trading an ice or something, and it might work pretty well. It's the submission I think we're making is about its wider application to the broader technical community, and the force of that submission comes from the fact that so much of ordinary business is moving into cloud services, which are hosted and supported at a high level by this infrastructure, and the users sort of create their own environments within that infrastructure for their specific purpose.
if I may put the questions or answer the question slightly differently in a different way around. You asked how is the bill balancing privacy concerns with the legitimate interests of law enforcement agencies appropriately. And I do hear your concerns, and of course the concerns specifically also with regards to child exploitations are absolutely valid. But by not including even the consideration of privacy for third parties, how can we say that we have appropriately balanced something if we haven't even included the consideration for privacy?
Sure. So if the judicial officer who was the issuing authority was required to consider privacy of third parties, would you have more comfort noting that sometimes, privacy may still be impacted if it's a legitimate pursuit of stopping the very real harm that's being done to, in this case, children?
Personally, I would, especially if combined with other measures like consultation and judicial authorization. I think it's the combination of measures. Consideration of privacy, judicial authorization, consultation. If we make a good package, then I think we're getting much closer to appropriate safeguards and a better legislation to enable enforcement agencies to do their job in a 21st century environment.
And if the privacy is compromised knowingly, because that compromise is warranted by the seriousness of the crime being pursued, that's a different situation to it being unknowingly compromised because the agency didn't even have to talk to the service provider and try and prevent it.
Sure, but I think that takes us back to the point that the Chair made when he started off the questioning, in that some service providers appear to be knowingly complicit in the provision of services that circumnavigate checks and balances by law enforcement. And in some of the examples given by the AFP, there is no obvious service provider to actually consult with. So I won't relitigate those points. I think the Chair made those quite well up front. Thanks, Chair.
Thank you very much, Senator Fawcett. Are there any further questions for the Communications Alliance? If there are no further questions for the Communications Alliance, thank you very much for joining us and your evidence today. You have taken a couple of matters on notice, and the committee may submit further questions to you on notice, so we welcome your assistance with that. You'll also be sent the Hansard transcript for any corrections that you'd like to suggest, and we look forward very much to your further cooperation with these issues.
Thank you, Chair, and to members of the committee for the opportunity today.
Thank you.
Thank you very much. Cheers.
Colleagues, we are slightly ahead of time, although I anticipate for our next panel, the Oversight panel, there will be a lot of questions. What I propose is we just have a short break now for 5 minutes, and if our Oversight panel is ready, and it appears that there's some of them in the room with us already, that we start early with them at 2:20. Okay, we'll just seek clarity that those witnesses are available to come early and appear early, and if they are, we'll resume at 2:20. If not, we will resume as scheduled at 2:30. which committee members I have with us to make sure we're quorate. I see Senator Fawcett, and it looks like Ms Hammond is there in the background as well, and Ms Ali in the background. Any committee members on the phone?
Yep. Mr Wilson on the phone.
Thank you. And either the Deputy Chair or Mr Dreyfus?
Yep, I'm here, Chair.
Great, okay. We are quorate. So on that note, we will resume early, and I thank the Inspector General of Intelligence and Security and the Commonwealth Ombudsman for being available to resume early, as no doubt we'll have lots of questions for you. At the outset, for the Hansard record, can I ask you each to state your full name and the capacity which you appear before the committee, and we start on your right and move across, and then at the end we'll do any witnesses on the phone. Starting on your right and moving across.
Oh, excuse me. I beg your pardon. Bronwyn Notson-Glenn, Acting Deputy Inspector General at the Office of the Inspector General of Intelligence and Security.
My name is Chris Jessup. I am the Inspector General of Intelligence and Security.
Michael Manthorpe, Commonwealth Ombudsman.
I'm Penny Mackay. I'm the Deputy Commonwealth Ombudsman.
Emma Cottrell, Senior Assistant Ombudsman.
And do we have any witnesses on the phone? No. Okay. In that case, I'll invite you to make a brief opening statement on behalf of each organisation, should you wish, and then we'll proceed to the discussion. First, Dr Jessup, do you wish to make an opening statement?
Yes, thank you, Mr Chairman. I take it that you have our written submission.
We do.
And I will not pretend to summarise that or to go over it in any way, but just draw your attention to a couple of the more significant points of division within that submission. So far as the amendments concern the IGES directly, we say something about that in paragraphs 40 and following of our submission under the heading Consequential Amendments to Expand IGES Jurisdiction. Those amendments are consequential apropos the chief legislative purpose of the bill, but they are central so far as our functions are concerned. Basically they involve the insertion of a new subsection 3A into section 8, which would give IGES oversight jurisdiction with respect to the intelligence functions of ACIC and AFP, and in turn the concept of intelligence functions is defined in a new definition in section 3, essentially to cover the network activity warrants obtained on behalf of those agencies. So far as the core content of the bill is concerned, that is to say where we find the substantial legislative policy of the provisions in the bill, we deal with that in paragraphs 22 and following, and there are three, these aren't the only ones, but there are three more important observations which we would wish to make, and in doing that we attempt to stay well within our remit, which is to comment on aspects of the bill which touch the procedures, functions and operations of IGES as an organisation, as an oversight agency, and to stay away from matters of policy which we do not regard as any part of our business. But those three things to which I would specifically draw attention are under the heading Scope and Definitions in paragraph 26 and following, and we there refer to what we describe as a cascading series of definitions about leading up to what is an electronically linked group of individuals. The omission from the criteria for the grant of a network activity warrant of any specific reference to privacy, which again is in itself entirely a matter of policy, and if that is what the Parliament wants, then we would have nothing to say about that. But we draw attention to the fact that this omission is almost conspicuous because privacy is referred to in quite a number of other provisions, including provisions in this bill. And the third one is the reporting time frames dealt with in paragraphs 38 and 39. And that relates to the fact that under section 49 of the Act, which section 49 subsection 1, which in itself is not being amended, there must be a report as soon as practicable after the end of the execution period of the warrant. Whereas in this particular context introduced by the bill, the 90-day period can be extended any number of times, and in itself that's fine if that's what the Parliament wants. But we simply draw attention to the fact whether this is a deliberate result of that or not. We don't know. We draw attention to the fact that that means that it pushes out potentially indefinitely the period by which or within which a report to the Minister must be provided. That is all I wish to say by way of opening statement, Mr Chairman. In other respects, we are able to, well, I may not be too bold as to say we're able, but we would attempt to answer any issues or questions the committee might have.
Thank you, Dr Jessup. Mr Manthorpe.
Yes, thank you, Chair. I welcome the opportunity to be here today, and we'll make a few brief opening remarks to contribute to the committee's consideration of the surveillance legislation amendment Identify and Disrupt Bill. I note that much of the debate that is contained in the various submissions to the committee goes to the high-level policy, purpose and design of the legislation. And generally speaking, like my colleagues from the IGES, we don't engage in those policy debates, and we don't intend to today, given that our legislative mandate, both in the Ombudsman Act and in the various other statutes with respect to which we play an oversight role, is focused on matters of administration rather than it is on policy. That said, however, we have made a submission that highlights a small number of points that we think might assist in the administrative design of the scheme. I also note that we have been consulted on the formulation of the bill by the Department of Home Affairs to ensure that there are oversight arrangements contained in it. Subject to the points that we've mentioned in our submission, we're generally satisfied with the design of the oversight arrangements, although I acknowledge that there could be a policy debate about whether they're adequate or not, but we will be entirely happy to and prepared to undertake such oversight as the Parliament determines. We are also pleased today to be appearing together with colleagues from the Inspector General of Intelligence and Security, particularly because, if passed, this bill will, for the first time, call on both of our agencies to play a role in oversight of the same entities. Up to this point, generally speaking, we've had a role with respect to law enforcement oversight, and our colleagues have had a role with respect to the intelligence agencies, and those have been delineated. So we look forward to working with colleagues from the IGES in a collaborative way to ensure that our respective roles are carried out in such a way as to build public confidence in the operation of the scheme in whatever form it passes through the Parliament. And with that, I'm happy to take questions.
Thank you very much. I have two quick initial questions and I'll offer the call to committee members. I have no doubt Mr Dreyfus will have questions for you, and Mr Wilson has indicated he has questions as well. If there are any other committee members who have questions, please indicate to me either directly or through the video or phone conference. First to you, Dr Jessup, I just want to clear up in my own mind this issue of the interaction between this bill and the Integrity Measures Bill that you mentioned in your opening statement. Is my understanding correct that your ability to provide the oversight required in this legislation is in part contingent on also the passage of the Integrity Measures Bill, and that they go hand in hand? Is that a correct understanding?
No. Our ability to provide the oversight for which this bill requires depends only upon the provisions of this bill. As you will be aware, the departmental preparation of the Integrity Measure Bill was at an advanced stage before the present bill came along, if I can use that expression. And a lot of the things which would have been in the Integrity Measures Bill will now be lifted into this bill, and if this bill passes first, the corresponding provisions of the Integrity Measures Bill are parked forever. They will never come into effect. If, on the other hand, for whatever reason, this bill does not go through and the Integrity Measures Bill goes through first, then the Integrity Measures Bill will operate in a way in which it was originally intended to do as a freestanding measure. It is complex, and I would hope that you don't lay the complexity at our doorstep, because it's really a matter for the ebb and flow of activity within the policy making space. But the bottom line is this, that if both bills are passed, the end result will be the same so far as our agency is concerned, no matter which bill is passed first.
Right. Okay. And look, this is not a hearing into the Integrity Measures Bill, but presumably, other than the elements of that bill which is picked up in this bill, there are other unrelated elements in the Integrity Measures Bill which would have an effect for your agency in due course.
Absolutely. The most obvious one, or one of the more obvious ones, is our oversight with respect to AUSTRAC, which isn't dealt with in this bill at all.
Yep. Okay, good, thank you. I just want to clear that up initially. A quick question for you, Mr Manthorpe. As you may be aware, the issue of who issues the warrants has been a point of contention for some witnesses before the inquiry. I just want to understand what your position is on it. I note you make a comment with respect to the account takeover warrants. Do you want us to articulate what your view is in respect to account takeover warrants and how that differs from any of the other warrants?
Yes, certainly, Chair. So the bill proposes to vest authority in magistrates to issue account takeover warrants and approve emergency authorisations, which is, as I understand it, broadly consistent with the arrangements that operate for overt warrants in the Crimes Act. But we see an important distinction here in relation to the covert nature of these powers, and suggest that it would be preferable for eligible judges and nominated AAT members to be the issuers of account takeover warrants and emergency authorisations because of consistency with existing covert regimes for things such as delayed notification search warrants, surveillance device warrants and retrieval warrants, computer access warrants and telecommunication interception warrants. With respect to all of those, it is judges and members of the AAT, as I understand it, who issue those covert warrants, and it seems to us to be sensible and consistent with those arrangements to approach it in that way.
Is that simply a matter of consistency from your point of view, or is there something inherent about a magistrate granting these warrants that's not preferable in your view?
I think it's not so much not preferable, but I think it's really that judges and AAT members are more accustomed, I think, to and have more background and expertise in the covert space. I think they're just well equipped to do it.
Okay. All right, thank you. Mr Dreyfus, I'll offer you the call, or one of your Labor colleagues if you prefer. If not, I'm sure we can go to Mr Wilson.
Thanks, Chair. I just have a couple of quick questions which go to the heart of some of the issues that were raised by the Chair in his questioning and some of your opening statements, which is ultimately that these laws would be quite, let's use the word, innovative. And of course, your agencies traditionally have oversight of more, let's call analogue investigations. I'm wondering whether there's actually a technical gap that could present itself, which might limit the capacity of IGES or the Commonwealth Ombudsman to be able to oversight the practical use of these powers by the Federal Police?
Well, I might. It's Michael Manthorpe here. I might have the first go at that. I think the answer to that turns in part on the way in which, let us assume that the bill passes as it is, but it will turn in part on the way in which records are kept as to how the powers are exercised by the AFP and the ACIC. Whenever a new regime of law enforcement powers has come into existence, one of the first things we do is sit down with the entities that we oversee and try to ascertain and work up a way to ascertain how we will oversight the operations of those laws so that the various requirements of the law can unambiguously be examined and then subsequently reported on. A large part of that, I think, is going to go to record keeping and the evidence base associated with how the powers are used. And if that is done well and transparently and soundly, then I think we are entirely well placed to engage in the oversight activity, just as we do for a variety of other telecommunications, surveillance device and other matters. So that'd be my starting position on that matter.
Can I just before I just might make comment, which is the whole point of your organisation is in part to hold agencies accountable where they may, without casting aspersions, choose to hide information or not reveal information in the fullness of, on the basis of separating or dividing power so that the public can have trust. One of the things about these powers is it creates an environment where they engage in the dark web or use access to access the dark web, and if you don't have the technical capacity to follow them and you're basing on the trust of the information provided by them, doesn't that raise a serious question about whether these powers may be abused and you may not have the technical capacity to identify?
Well, we don't have the technical capacity to observe what is being done covertly by an agency exercising covert powers. But we do have the technical capacity to inspect, go in, look at, question, seek evidence. We typically do that after the event, but we could do it during the event if we felt there was a need to. The other point I'd make is that whilst it's true that with respect to this regime, just like the other regimes in the law enforcement space that we oversee, on one level our oversight can be thought of as a sort of a series of tick boxes. You know, if the warrant was issued for X number of days, did an agency use it for more than that number of days? Or if a warrant was directed at a particular target, did they focus on that particular target? Those sorts of things that go to ensuring that the warrant or the power is used consistent with what has been authorised. So in one sense, we go through a list of tests and tick them off consistent with whatever the legislation says. But we do have wider powers, including to conduct investigations on our own motion under the Ombudsman Act. Now, that's not provided in this bill, but in a sense it doesn't need to be because we have broader powers under the Ombudsman Act. So if something came to our attention that suggested that the powers were being misused in some fashion and we weren't being appraised of that, we could undertake own motion investigation activity, just as in fact we have in relation to some matters of use of telecommunications data, for example, in the recent past.
Do IGES representatives have anything they want to add?
Well, did you want me to answer this question with respect to the network activity warrants, which is the
I mean, that's the only one that IGES has a role in, as I understand it. That's the one that IGES has a role in. Yeah.
Yeah, that's the only one that IGES has a role in, and I don't believe that we would be embarrassed by any shortcoming in our technical capacity to investigate the range of matters that are committed to our oversight under the bill in relation to those warrants. I don't know whether I've understood the question correctly, but I wouldn't think that we would be in any difficulty, unless you're referring to purely technical things, such as the intricacies of how the computer networks operate and things of that kind. That would obviously, if that's the situation, we will need to ensure that we are sufficiently staffed or advised or both to get on top of those matters.
So just on those points though, if you identify that there is a limitation and you seek advice, does that mean you bring it internally, or do you bring it from, you'd seek it, external expertise, and where would you then seek it from?
Where would we get the expertise from?
Yes. On the technical side of...
On the technical side? I don't think that we've crossed that bridge in anticipation of the event. Just a moment.
I understand, but just from the committee's perspective, and considering the capacity for oversight of this legislation, if it were to come into operation, part of the critical test, both for the IGES and for the Commonwealth Ombudsman, would be that they were up to the job of oversighting the activities that these warrants would provide, and make sure they have that capacity to do their function. And so that's the basis of my line of query. And so if IGES has accepted that they may not have the technical capacity, if the Ombudsman has said that they wouldn't be necessarily able to replicate and would require, I guess, and I don't want to verbal the Ombudsman, but essentially factual information from the police when there may be, when the whole point of, in part, oversight is to identify where they've done where people may have not used their powers correctly. It raises questions about whether, if these powers are granted, you could fulfil your function oversighting agencies to do their job.
Well, look, the way our office operates in any event is by way of oversight of the agencies that are within our jurisdiction. Now, we already oversight or oversee complex technical matters in other contexts, and we work in cooperation with the agencies themselves. We have already had briefings from the two agencies with which this bill is concerned, ACIC and AFP, and each has promised us a level of cooperation which gives us every optimism that we will not be embarrassed by any of those kinds of shortcomings. So we will be regularly in communication with the agencies themselves. We expect to be briefed by them, and I just don't anticipate having problems of that kind.
And can I just add to that? It's Michael Manthorpe again here. I too would suggest that my office has quite strong technical expertise when it comes to scrutinising the records and actions of law enforcement agencies, including in the in quite technical spaces, it is true that we don't bring any immediate expertise in relation to accessing the dark web and criminal activity that might be going on there. But I'm quite confident that we can bring the necessary technical expertise to bear to the task of testing whether what the law enforcement agencies are doing is consistent with the law. So I think as we roll out our oversight, and we will do so in a way that is very cognizant of how the agencies are operating under the law, I'm confident, as is I'd echo what Dr. Jessup said. I'm confident that we will not be embarrassed for lack of technical capability.
I think Dr. Ali has a follow-up question, Chair.
Yes, please ask.
Thank you, Chair, and thank you, gentlemen. I do have a follow-up question in the line of Mr. Wilson's questions around technical capability. And I don't know if any of the current witnesses were listening to the previous witness who put in a suggestion that there would be some form of independent technical advice or a form, as a kind of a form of consultation in the execution of warrants. And I was wondering if the current witnesses had any opinion or any input into that recommendation that was made by the previous witnesses.
Would you just repeat the last part of that question? It related to the recommendation made by the Richardson Review.
No, made by the previous witnesses, which was the Communications Alliance, where they recommended an independent process by which technical expertise could be sought in the execution of a warrant, along with consultation of the platform providers.
Well, I regret to say I haven't. I'm not familiar with the evidence that the committee has heard prior to our arrival here today.
You're very welcome to take that on notice if you prefer, Dr. Jessup.
I think I will, if I may be permitted to take that on notice and provide an answer to you.
Yeah, and it's Michael Manthorpe here. Ms. Ali, I'll also take it on notice, but I'm not aware that we've had any engagement with the Communications Alliance on that question. All I would add is, so we'll take on notice whether there's anything more that we can contribute on this point. All I would add is that, of course, if additional safeguards were put into the bill, and that essentially is a policy question, whether that happens or not, but if additional safeguards are put into the bill to address some of the sorts of concerns that are being raised, then we would, then I would still maintain that we have the technical capability to ensure that the additional safeguards, if they're in the bill, are then adhered to, and that would be our goal in designing the oversight approach.
Thank you. And so you're maintaining that your technical capabilities in-house are currently adequate to deal with what the bill is proposing?
To the best of my knowledge, and so long as I said in response to the first part of this line of questioning, so long as the record keeping and evidence base is present in the law enforcement agencies, so that when we come along to inspect, it's there and can be seen and worked through transparently and clearly and methodically. So long as that is the case, then I'm confident we have the technical capability to deal with the oversight role.
Right. Thank you, and thank you, Chair.
Thank you. Deputy Chair, and then Ms Hammond, and then Senator Fawcett.
Just one very quick comment, Chair, particularly directed to IGES, and it's not a question, it's a comment. I think for other committee members, IGES already has the powers to, AGO has many of the powers that we're debating. IGES oversights those powers, and I've been very confident that the Office of IGES has done its job in providing the requisite advice to IGES with respect to the powers that our committee has given ASIO, which they will be using And just another reflection on that note is that one of the better reports I'd ever read in terms of, from an oversight function perspective, was the Insulum report on Toller. So I've got, notwithstanding my earlier sort of investigation with the Communications Alliance about another office technical capabilities, as it stands at the present period of time, I have great confidence in just directly in terms of the powers that have been granted the agencies of IGES as well as Insulum and their capacities to make the requisite inquiries, provided they're appropriately resourced and as the Ombudsman said, provided that the agencies keep appropriate records. I'll leave it there.
Thank you. Ms Hammond.
Thank you, Chair, and thank you all. My questions are to IGES, and they might be picking up on what others have questioned before. I think when we put in place powers like this, it is very important that there is proper oversight and that the oversight bodies who are given that power have great clarity in what they're overseeing. So in relation to the IGES submission, paragraph 33, the cascading definitions are complex and potentially unclear in scope. This could create challenges for IGES oversight. Can I have some, again, in perhaps non-legal terms, what are some of the issues? Because we want to make sure that IGES has a very clear capacity to oversight. What are some of the challenges that you see with these definitions as they stand?
Well, if you have the submission before you,
yes,
paragraph 33 really summarises the situation which we describe in paragraph 26 to 32, and in particular refers back to the cascading definitions to which we've referred in paragraph 27. So, for example, and I'm really only elaborating on what's here in the submission, you have an electronically linked group of individuals. That's a kind of a point of tether for the operation of other provisions in the proposed legislation. That term has its own definition we've set out in paragraph 29 as a group of two or more individuals. Each individual in the group does or is likely to do one or two of the following things, and they're set out. Now, first thing we would mention is that you have to have a group, and the bill doesn't provide a definition of what a group is. Now, of course, no bill can provide a definition of every word in the English language, but we think that there could possibly be issues if someone who was on the same kind of website or web communication system, whether it be a chat room or anything, and they might be there simply passively, or they might have stumbled upon it accidentally, whether they could be regarded as a group. And if they are part of the group, then they are using the same electronic service and so forth. So what we've said in paragraph 30 is that the EM for this bill suggests that passive engagement with the same electronic service would bring an individual within the definition of an electronically linked group of individuals. Now, on one view, the EM in that respect may be seen as going beyond the terms of the legislation, but on another view, if the word group is in itself of uncertain meaning, one is entitled to look at the EM to see what Parliament really intended. Now, it's no part of our remit to suggest that Parliament should go one way or the other, but if Parliament intends a particular outcome, the point we're making in this part of our submission is that it should actually say so
Yes.
because it makes our job easier to oversight. What we don't want to do is to get into an argument with AFP, for example, over whether the people they're targeting are a group or not.
Yes.
Our job is oversight. It's not giving rulings on the right and the wrong legal answer to a legal question. So it's in a sense a little bit of a plea. That's the kind of thing we're talking about in paragraph 33.
Yes, okay, that I do understand that point. So it's a bit of a plea for the clarity and not getting into a legal dispute with the AFP. Yes, thank you very much, Mr. Jessup. That's all I have.
Thank you. Senator Fawcett.
Yeah, thank you. My question is for Mr. Jessup, but the Ombudsman wishes to take a parallel slant. He's very welcome to. Can I go to section 27KM, which is addressed in paragraphs 34 and 35 of the IGES submission? And it goes to the fact that a judge or AAT member has to take into account in determining the application for a network activity warrant. Subparagraph F goes to the extent to which the execution of the warrant is likely to result in the access to data of persons who are lawfully using a computer, which at a superficial read, as you indicate in your submission, implies privacy. And I guess this is a similar point to what you've just discussed with Ms Hammond, but you go on in paragraph 35 to say some more clarity would be good. What change to the proposed legislation in section 27KM would give you the clarity around the fact that you are actually considering privacy here? And as you are evaluating the submission, because I know you say you have no oversight on the judicial decision to grant or not grant a warrant, but as you look at the efficacy of the submission which is put forward by the agency, what balancing information, what additional information in the legislation would help you to assess whether the submission from the agency is a fulsome and balanced submission going to that judge or AAT official?
Well, that really is a policy question. Our role here is to draw attention to the fact that, at least in some circumstances, privacy may not be the same as the circumstances referred to in paragraph F. Now, having your data accessed by an AFP or an ACIC may well be a breach of your privacy. On the other hand, the concept of privacy may be in particular circumstances wider than that. That is to say, it might be that one's privacy is invaded in ways which don't involve access to data in those terms. Now, as we've said, it's not apparent to us why this particular formulation was preferred to the more commonly encountered reference to the rights of privacy. Privacy is referred to in the definition of human rights in the Australian Human Rights Commission Act, in the covenant in the schedule of that Act. It is something that our agency is always concerned about because of its remit under its legislation, and so we draw attention to it. And I noticed that the Ombudsman has done likewise in his submission. in terms which are relevant to his area of jurisdiction. That's all we really wanted to say here. I know that you're inviting me or laying down the challenge to explain how privacy would differ from paragraph F and perhaps how it would be any improvement on paragraph F. That's almost like a challenge for me to anticipate the wide variety of personal circumstances which might find themselves caught up in the execution of these warrants. So I can't really go any further than that to say at base it's something for the Parliament, but we would like to think that the Parliament had actually considered this and decided to have paragraph F in its present terms rather than simply something which was slipped between the cracks and wasn't thought about.
I hear that. I guess I point to the concluding sentence in your paragraph 35, which says clarity on the extent to which the right to privacy is intended to guide the use of network activity warrants will assist the IGES in the exercise of its legality and human rights oversight functions. So I guess I was looking to see if you had any thoughts on how that clarity might be provided, but we will perhaps need to go away and think about that. For the Ombudsman, would you care to make any comment in a similar vein?
Yes, Senator Fawcett, thank you for the opportunity. So we note that you've been discussing the privacy issue with Dr Jessup in relation to the network activity warrants that the IGES will have oversight of, and we made a broadly comparable point with respect to the data disruption warrants, that is that the bill doesn't require issuers and therefore the law enforcement agencies to consider privacy impacts when determining whether to seek or issue a data disruption warrant. And we acknowledge it's not always going to be straightforward or even possible to determine the full extent of privacy interference in using the data disruption power, but that is also the case for other covert powers which nonetheless require a consideration of privacy impacts in determining applications. That includes other existing and proposed warrants that authorise covert access to data held in computers, specifically computer access warrants, account takeover warrants and network activity warrants. So due to the covert nature of the data disruption power, people affected by them will typically be unaware of their use. And so requiring issuers, or indeed the law enforcement agencies, to at least consider the individual's privacy ensures that people's mind have been turned specifically to the balance between the right to privacy and the safety of members of the Australian community when deciding whether to authorise the use of particular powers. So really, we too are simply raising the issue as one that the Parliament may wish to consider.
Sure. Thank you. Second question, the Uniting Church Synod in their evidence looked to some of the Ombudsman's reports about implementation of existing powers by agencies and highlighted that with the exception of a small number, predominantly process-driven issues, that there was no real concern raised about the intended and effective use of existing powers. Would you care to summarise in terms of your oversight whether you concur that that's the intent of your report, and also whether there is any correlation that you're aware of the difference in outcomes if the authorising officer is a member of the AAT as opposed to a judicial officer appointed in their own right by the Attorney General?
On the second point, I don't think I am able to identify any differentiation in terms of the outcomes we see from our inspections as in relation to warrants or authorisations that might be made by a judge versus a member of the AAT. I don't think we've seen anything that illuminates that question one way or the other. In relation to the first question, we oversee to quite a significant degree the Commonwealth law enforcement agencies, but also state and territory police forces and integrity agencies in their use, to the extent that they use various Commonwealth covert powers. In many cases, we see good practice. In some cases, we see administrative slip-ups and errors of various kinds. But from time to time, we also do see and report on quite, significant oversight, slip-ups, lack of reporting, things of that kind, which for us reinforce the importance of having robust oversight. And we periodically engage in quite real conversations with law enforcement agencies about those things. I think that the senior people in the law enforcement agencies we engage with really do understand that they need to take these issues seriously, but sometimes I think in the day-to-day work of prosecuting or pursuing wrongdoing, shortcuts can be taken and mistakes can be made by well-intended but sometimes mistaken individuals.
I guess the thrust and part of my question is that concerns have been raised by earlier witnesses that whilst the intent of these new powers in all three areas is supported, and certainly the examples you've given by the AFP focus around things like child exploitation, concerns raised by witnesses is that the wording of the legislation is sufficiently broad that they can construct a range of hypothetical cases where the application of these powers could be made to things as diverse as bigamy or I think it was poaching dolphins or some such activities, or even interfering with the freedom of the press. And what I'm seeking to understand is, are the existing powers so tightly defined that it provides for that good behaviour with the occasional error in process, or are the existing powers likewise somewhat vague and extrapolations or hypotheticals would be possible, but the checks and balances of the judicial oversight, your reporting, etc., and the goodwill of the agencies is what actually keeps it on track? So should we be able to extrapolate from current behaviour to these new laws?
I think in broad terms, the answer to that is yes, so long as the conditions that I was referring to earlier are met, which goes to adequate reporting, adequate transparency, a commitment to full and frank disclosure. Incidentally, I should add, one of the things that we see one of the things we seek to encourage from the law enforcement agencies we oversee is self-disclosure when they've made a mistake. My office put out a report a couple of years ago about a journalist information warrant slip-up by the AFP, which, to their credit, they identified and self-disclosed, and we came in and did an inspection to see what had gone wrong and come to terms with it. So if that culture prevails, then the combination of oversight around the front end of matters of warrants being given, and the oversight of the back end by my office and others, and by this committee and the Parliament and so on, I think can provide a reasonable degree of assurance. But equally, I totally appreciate that these regimes that are the subject to this bill are highly intrusive, and I can see that there is a live policy debate in front of you that I'm not going to wade into as to whether more should be done.
Okay, thank you very much. Thanks, Chair.
Thanks, Senator Fawcett. Do any other committee members have further questions? If not, I'll try with one, although I anticipate there may be some reticence in answering. You may be aware from the evidence we've collected from other witnesses today that one of the contentious issues with the bill is the threshold at which the powers could be used against, and the bill suggests a 3-year crimes attracting 3 years or more imprisonment. I wouldn't ask you, of course, to comment on the appropriateness of that as the threshold, but perhaps the precedent or other similar thresholds in other areas of law, other novel powers like this, and what the thresholds are.
I don't think I've got a comment on that. I think that takes me to the policy realm.
Well, I think what we can comment on, though, is just, so in terms of the other regimes that we currently look at, sorry, Emma Cottrell, Senior Assistant Ombudsman, in terms of the regimes that we currently assess for law enforcement agencies, these thresholds are consistent with the acts within which they're proposed to be contained. So at the moment, you know, you're looking at the data disruption warrant, the threshold is 3 years. That's consistent with the thresholds that already exist within the Surveillance Devices Act. And essentially is the point at which agencies may use those powers, provided the offence is punishable by a sentence of at least 3 years. So, look, I mean, I think we can say it's consistent with what we currently do. We don't have a view about whether it's right or wrong, but it's certainly consistent with, there are a wide variety of offences that law enforcement agencies may use the powers for currently, and this would essentially just bring in a new power that they can apply to the same set of offences.
Thank you. And from an intelligence point of view, from IGES point of view?
When you refer to threshold, Mr Chairman, you mean the threshold you have to cross in order to secure a warrant?
Yes, that warrants can only be granted in investigating a crime that attracts a sentence of 3 years or more, or some other conditions as stipulated in the bill.
Well, look, it does seem to us that one size doesn't fit all if you look at other legislative provisions. Now, there may be good or good reasons or no reasons for these differences, but we took the view that the Parliament intended them and that it was something for the policymakers.
Senator Keneally, I think, had a follow-up question on this issue.
Yes, thank you, Chair. Just back to the point that the previous witness, I apologise, I missed your name.
Ms. Cottrell,
the woman who was, yes, thank you. Where you said there seemed to be some parity amongst the various warrants that you oversee, but that raised to me the question of particularly a data disruption warrant, which is not an evidentiary warrant or an information gathering warrant, but in fact a far different warrant to those. And I just wonder I may be straying into the realms of policy, but I'm wondering if you could reflect upon whether the warrants that you currently oversight are different to a data disruption warrant.
Look, I think it's clear they're used for different purposes. I think it would be a matter of policy whether government considers that they should have the same offence threshold. Do you know what I mean? If they're seen as more intrusive, then that's essentially a matter for government if it'd like to lift the threshold. I don't think it's something we would be inclined to comment on, other than to say that all of the, they certainly are primarily going to be used, obviously, to disrupt, but may also be used for evidentiary purposes.
I suppose if I can ask the question in this way, when you made reference to other warrants that you oversight, do any of them have this type of purpose that are similar in purpose to a data disruption warrant? That is, that they are not evidence, they're not there to gather evidence, they're actually there to stop crimes being committed.
That might be something, we might take that on notice, Senator Keneally. I'm happy for us to go away and think about whether we can add anything useful to your, to respond to that.
Great, thank you.
Thanks, Senator Keneally. Are there any other further questions from committee members? If not, can I thank both of you and your organisations for appearing and your helpful assistance to the committee. I'm not sure if you've taken any questions on notice, but you may also receive some after the fact from committee members in writing, and we'd be grateful for your assistance in answering those. You will also be sent a copy of the Hansard transcript for any suggested corrections you might like to make, but we look forward to working with you on this and other matters going forward. Thank you. Now, the committee is due to move to the government panel of Home Affairs, AFP and others at 3:30. I believe some of those witnesses are already in the building, but perhaps not all of them. Why don't we take a short break, and if we're able to commence a little bit early, we will. If not, we'll commence at 3:30 as scheduled.
Thanks, Chair.
The committee will now resume, and I welcome representatives from the Department of Home Affairs, including representatives from the Australian Federal Police, the Australian Criminal Intelligence Commission and the Australian Signals Directorate to give evidence. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee, starting from your right?
Thank you, Chair. Michael Phelan, I'm the Chief Executive Officer of the Australian Criminal Intelligence Commission.
Kath Patterson, Deputy Secretary, Strategy and Law Enforcement, Department of Home Affairs.
Andrew Warnes, Acting First Assistant Secretary in the Electronic Surveillance Reform Task Force in the Department of Home Affairs.
Rhys Kershaw, Commissioner of the Australian Federal Police.
Rachel Noble, Director General of the Australian Signals Directorate.
Ian McCartney, Deputy Commissioner of Investigations, AFP.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Can I ask for some clarity on opening statements? Does each organisation wish to make an opening statement, or will Home Affairs do one on behalf of everyone, or in fact is there no opening statements at all?
Chair, Home Affairs will do one opening statement and Commissioner Kershaw will do another opening statement.
Okay.
That's okay with you?
That certainly is. Ms Patterson, I invite you to commence, and then Mr Kershaw, I'll call on you.
Okay. Thank you, Chair and Committee, for the opportunity to make an opening statement and appear before you today as part of your review of the Surveillance Legislation Amendment Identify and Disrupt Bill 2020. In recent decades, advances in technology have profoundly impacted our law enforcement and criminal intelligence agencies in ways that both assist but also challenge those agencies in keeping our communities safe. In 1979, when Commonwealth telecommunications interception powers were introduced, agencies could be confident of intercepting most or all of a criminal's electronic communication through one phone, one number and one provider. That time is well and truly past. As communications technology continues to evolve, so too does the tradecraft of criminals. The growing use of the dark web and anonymising technologies that conceal the identities, true IP addresses, activities and locations of criminals are increasingly hampering investigations into the most serious of crimes. This includes child sexual abuse, terrorism and the trafficking of firearms and illicit drugs. Existing electronic surveillance powers, while essential for investigating many aspects of online crime, do not allow our agencies to fully engage in the fight against serious crime when anonymising technologies are being used, including at scale, to allow criminals to evade law enforcement and criminal intelligence efforts. We simply cannot allow serious crimes to occur online any more than we would in the physical world. We do not accept serious crimes in our homes, our streets or our communities, and neither can we accept it online. Serious crimes occurring online must not be immune from prosecution because agencies have not been given the powers they need to stay ahead of criminals' use of technology. Investigations into online criminality must adapt if our agencies are to continue to do the job we expect of them, keeping Australians safe. This bill ensures our agencies have the powers and capabilities they need to combat serious crime perpetrated using anonymising technologies and the dark web. The bill introduces 3 new powers for the Australian Federal Police and the Australian Criminal Intelligence Commission to achieve 2 things: identify and disrupt serious crime online. First, the bill introduces a network activity warrant to enable the AFP and ACIC to collect intelligence on criminal networks operating online. This will enable investigators to identify offenders and understand the scope of their activities to build a full picture of how criminal networks are operating online. The intelligence gained through this will inform investigations by enabling law enforcement to strategically target criminal networks of the biggest threat to maximise impact. For example, by collecting intelligence on how dark web marketplaces operate, the AFP and the ACIC will then be able to target the persons accessing those marketplaces to buy and sell illicit drugs. Second, the bill introduces an account takeover warrant to allow the AFP and ACIC to take control of a person's online account for the purposes of gathering evidence to expose and respond to online criminality. When used in conjunction with other powers available to law enforcement,
Account takeovers will provide officers with another avenue to uncover the identities of criminals operating online, identify potential victims, and gather evidence about the criminals' online offending and the activity of their associates. Third, the bill provides the AFP and the ACIC with a new power to disrupt online criminal activity through the data disruption warrant. The data disruption power will enable authorities to remotely modify data of targets to frustrate ongoing criminal activity and protect individuals from further harm and victimisation. For example, during an investigation, agencies may become aware of an online database of child abuse images. By modifying and deleting the images to prevent their proliferation on the internet, the agencies can reduce the further victimisation of the children in the images while police work to bring their abusers to justice. Each of these powers is supported by strong safeguards, including independent issuing authorities, robust oversight by the IGIS and the Commonwealth Ombudsman, and controls on the use of information. These safeguards will ensure that the AFP and ACIC use the powers in a targeted and proportionate manner to protect the community, while also minimising the potential impact on legitimate users of online platforms. The bill also makes minor amendments to the Crimes Act, in particular the requirement for illicit goods to be under the control of law enforcement at the end of a controlled operation conducted online. This is necessary because of the nature of illegal content, such as child exploitation material. This data is too easy to copy and disseminate for law enforcement to guarantee it will be under their control at the end of a controlled operation conducted online. The Identify and Disrupt Bill is critical in ensuring that Commonwealth law enforcement and criminal intelligence agencies are able to adjust to fundamental shifts in how serious criminals are operating in the modern environment. This is especially pronounced where offenders are actively seeking to obfuscate their identities and activities through the use of the dark web or anonymising technologies. I'd like to thank the committee for their consideration of the Identify and Disrupt Bill and answer any questions you may have. Thank you, Chair.
Ms Patterson. Commissioner Kershaw.
Good afternoon, Chair and committee members, and I thank you for the opportunity to make an opening statement. The new powers proposed in this bill are a key step forward in enabling law enforcement to tackle the fundamental shift in how serious criminality is facilitated online. Our focus in the AFP is keeping our community safe and protecting Australians from harm. Unfortunately, we are currently seeing a continual increase in the volume of harmful criminal activity being committed online, some of it exacerbated during the pandemic. At the height of COVID-19, we saw a worrying rise in traffic to the dark web, including 168% more child abuse material, too often of children being tortured and raped, and identified during the first quarter of 2020 as opposed to the same period in 2019. The scale and frequency of cyber attacks targeting everyday Australians continue to grow. Report Cyber receives a complaint every 8 minutes, and in the 2019-20 financial year, almost 60,000 reports of cybercrime were submitted. And the financial impact of cyber scams alone for everyday Australians was more than $634 million. And Microsoft reports the direct economic loss of cyber incidents for Australian business is even higher, estimated at $29 billion per year for industry and $7 billion per year for the government. Criminals are also exploiting advances in anonymising technology to commit serious crimes. And the cloak of anonymity allows child abuse, drug and firearm trafficking, fraud, including stealing Australian identities and selling them overseas, and violent extremism to go undiscovered by police until the impacts are felt by victims in our neighbourhood, on our doorstep and inside our homes. We know that people drawn, and especially young people, to extremist ideologies are communicating using social media and closed forums in encrypted communication platforms. Where we can see it, we are observing their behaviour escalate unpredictably and sometimes quickly. That makes us very concerned about the behaviour we cannot see. As police, we know no crime is victimless, and we will always seek to take action which prevents or reduces harm to victims. I want to emphasise that disrupting crime is a core business for the AFP. And there is a misconception that disrupting crime means that an investigation will never proceed to prosecution. This is simply not true. Many of our disruption efforts still result in the prosecution of offenders. And the best example of this is our unrelenting efforts in uncovering illegal drugs imported to Australia. We can simply seize the drugs at the border and arrest an offender or two if we identify them at that point. But we can also take a different approach to disrupt the harmful effect of drugs in our community. We seek to discover who sent the drugs, who bought them, and their distribution points. We take law enforcement action at an appropriate time, but we also disrupt the immediate impact of drugs entering our community, identify a larger number of offenders, and have a better chance at reducing future harm. But in the online environment, we're far more restricted in how we can track illegal activities in this way. We can assume identity and interact with offenders. We can get targeted warrants to intercept their communications and access their data. And with Toller Industry Assistant Framework, we can get help to open the front door. But we've still got one hand tied behind our back because we cannot identify what their distribution point is and what criminal network they belong to, understand what they are communicating due to encryption, move things around inside their network, i.e. modify data, take control of their distributors to collect evidence. And in many cases, we may not even know where the distribution network is. And criminals should not be able to conduct serious crimes online and get away with it just because our laws have not kept pace with changes in technology. I want to reassure the Parliament and the community that the 3 new proposed powers will be sought and used appropriately by the AFP and that we welcome the robust oversight set out in the bill. This includes both the thresholds and other issues we need to demonstrate before we can obtain a warrant from an independent issuing officer in the first place, as well as the scrutiny of our subsequent actions by oversight agencies. I was grateful for the opportunity to brief a number of committee members in the last fortnight in a classified setting, and my team and I openly explained the operational threat environment and the extent of our current capabilities to address technology-enabled crime. While we may be limited in this public forum in discussing our sensitive capabilities and operational methodologies, we will do our best to answer your questions in order to demonstrate the necessity of these powers. And because we do need them, if we want to get better at addressing crime facilitated online before the devastating effects reach the most vulnerable in our community and tear down the fabric of our society. Thank you.
Thank you very much, Commissioner Kershaw, and let me respond in kind on behalf of the committee by saying thank you for that briefing that you did offer committee members, which helped get our heads around some of the technical aspects of these issues. I'll start with some questions which are directed generally at the panel, and whoever feels best able to answer them, please do so, and then I'll offer the call to Senator Keneally and other committee members after that. And I want to give you effectively an opportunity to respond to some of the evidence the committee has heard today from other witnesses. I don't know how much you're following it, so I'll do my best to briefly summarise it. Some witnesses questioned the necessity of these powers altogether, or at least some of the powers that are proposed, on the basis that Mr Richardson, in his review, did not believe they were necessary. So whoever feels best able, could you explain why the government has disagreed with Mr Richardson's recommendation and proceeded with this proposal?
Thank you, Chair. So I think we had the benefit of the Richardson review at the time of pulling this legislation together, and as you noted, the government did disagree with that recommendation. But in framing the actual breadth of the offence, you would have noted what Mr Richardson's report was quite critical of was the ability to destroy or damage computers. I think the quote, and I don't have the Richardson report in front of me, sorry, but was to zap a computer and to in effect be judge, jury and executioner. I think I'd say that legislation as framed, if we're talking particularly about the data disruption warrant, does not do that. It's quite limited in the damage that it can do, and it can't do any damage to physical property to cause a monetary loss. It can't damage other property. It's focused narrowly in on disrupting data. And so there's been an effort made to actually really focus in what we're about here. And I think the operational examples, which I can go to from AFP and others, is that it really goes to that ability to target in on data and not to actually do that substantial or major damage that Richardson was referring to.
Okay. Two other themes came up in those who had concerns about these proposals or critical of the proposals. One is around the definition of the relevant offence that these warrants could be sought for, and in particular the 3-year threshold as specified in the bill. Could you first explain why that threshold was chosen? And then I'd be interested in your comment on what the consequences would be for the operation of this framework if that threshold was increased, for example, to the proposal of the Law Council of 7 years instead of 3 years.
Yeah, thank you very much, Chair. I might start and let others jump in. I think the first reason was that it was chose with an eye to consistency with the Surveillance Devices Act. And so when you have legislation as this does, which amends the Surveillance Device Act and inserts these new powers, these powers in their different ways will build off existing capability. So a network activity warrant, as we've indicated in some of the examples in our submission, will actually be used as a first step then hopefully to gather intelligence that allows the use of more targeted warrants. If you change the thresholds, you break that nexus, and potentially then offences that you can get ultimate targeted warrants for, you won't be able to get and do the intelligence work that the AFP has said they need to do to be able to identify that offending. So that was really the notion, to make sure it was targeted but also consistent across the Act. The other point that I think I would make when it comes to account takeover warrants is very similar, that was also set at the 3-year threshold because they are a very, very narrow warrant. I'm not sure that's fully come out in the hearings today, just how narrow they actually are. They are not actually to enable access to data. You will need other warrants and other warranted powers to do that. They are only able to be used to take over the account, and that is it. So that was the gap that was identified in consultation with the AFP and others, that power where offenders didn't or suspects didn't consent, there was no way to actually compel the takeover of that account and conduct law enforcement operations. So you need to again be able to match that threshold with the same thresholds that you're then going to use the subsequent powers once you've gotten an account takeover power, because it's very hard. And maybe the AFP can comment further, but it's very hard to imagine a situation where you will have an account takeover warrant but not some other type of warrant or controlled operation that is happening to actually then do the activity once you've got control of that account. On the second part of your question, Chair, I don't think I could probably put it any more eloquently than Dr. Zernzak put it from the Uniting Church when he stepped out why a range of offences that may appear minor on the face of them, and that's it's a very subjective test, right, to look at each offence that's given a 3-year threshold and try and work out whether or not it's actually serious. Objectively, Parliament has set that threshold at 3 years, and in our view, there must be some correlation to the seriousness of those offences. Now, of course, the gravity within any offending in any particular circumstance can change and is different. That's why you have maximum penalties, and it may be that when you go to a judicial authority to get authorisation, if the gravity of the offending for that particular offence isn't significant enough, you would expect that the warrant would be denied. But there's a rate, when you start carving out offences, you run the risk of missing things. You run the risk of, I think Dr. Zernzak put it as like that sort of tip of the iceberg, where some of that minor offending may actually lead you to more major offending and more significant offending. So that's why it's very difficult. The other thing I'd note in the Telecommunications Interception Access Act is people use colloquially the 7-year threshold, but I have to say under 5D of the TIA Act, the Telecommunications Interception Access Act, there is a range of exceptions to that. So it's not just 7 years, there's a range of, for example, computer crimes that have been added in. So there are offences, I think, and I'm happy to be corrected, a bit of 3 years and 5 years and other kind of ranges where you can use interception powers. So 5D is not just a 7-year.
Okay. Yeah, please, Commissioner.
Chair, please. So for us, that threshold in the bill is consistent with the Surveillance Device Act and the Crimes Act, and we believe it's necessary and appropriate. Anonymising technology, encryption on the dark web can be used to facilitate any crime type, and they don't differentiate with the use of technology. And so we focus our finite resources on serious crime, which harms our community. So whether we are progressing an investigation and elect to apply for a particular warrant, which will always depend on specific circumstances of the case and the level of suspected criminality and harm involved. So for us, the 3-year threshold it also ensures we can investigate all relevant telecommunications and computer offences in the criminal code, where the majority of offending will be facilitated using computer networks and where evidence will be held in computers. So for us, limiting the powers to specific listed offences is not workable, as organised crime groups may be involved in multiple types of offending, all of which can be facilitated by anonymising technology on the dark web.
And that point about your scarce resources is a really important one. I assume you and all your officers are going to use any powers you're granted to pursue the most serious offending. But the Deputy Chair did make a good point with previous witnesses that the intention of the metadata regime was to be only reserved for the most serious offending as well. And we know it has been used by the proverbial dog catcher and local council parking inspector. So the committee might want to assure itself that there are really robust measures, not just in your assurances as a professional public servant, but in the legislation itself, that this wouldn't end up being used for more trivial examples. And some of the examples cited today include the importation of a dolphin and at family law matters and disobeying a public health direction. Given that these are extraordinary powers, I think it's possible that the public will be more comfortable if they knew that it was reserved only for the most extraordinary offences.
I think we step back and we look at the legislation. Obviously, we're focused on serious criminality, and in general, those offences will be at the higher end in terms of the penalties. But we do need operational flexibility in terms of the work that we do, and there are offences even at that 3-year level that we believe would be of potential relevance, including with the offence of associating with a terrorist organisation, which is a 3-year offence. That's a terrorist offence. And in particular, using a carriage service to menace, harass or cause offence, section 474.17. And that was a relevant offence that we led during the Eden Monaro by-election in terms of that sort of activity. But I think there's a really other important point. In terms of obtaining these warrants, we need to show the issuing officer that and he needs to consider whether the activities authorised by the warrant are proportionate to the likely benefit we'll obtain through those activities. So those sorts of issues in terms of the seriousness of the offence will be taken into account by the issuing officer.
That's a very good point about those specific offences. One of our witnesses today, the Cyber Research Cooperative Centre, said that rather than lifting the threshold in terms of years, perhaps particular categories of offences could be excluded. But I'm also sensing in your answers that you have concerns about that approach as well.
Well, I think we're looking at organised crime, and I think organised crime are not focused on one particular form of criminality. We're looking at polycrime. So the syndicates that we investigate now are involved in a range of criminality, and we need the flexibility in the legislation to apply that legislation to those types of groups.
And I also appreciate the point you made, Mr. Warnes, about consistency. Of course, that makes sense, but I think probably most witnesses, even those supportive of the bill today, have acknowledged that these powers go far beyond existing powers, that they are extraordinary powers, and that just seeking to be consistent with current oversight may not be sufficient, that stronger oversight might be necessary to match the strength of the powers proposed.
Yeah, look, we've certainly heard that argument throughout the day. As I said, I'm not sure we described the account takeover warrant. For example, as I said, it's quite a limited power in what it actually enables.
Yeah, I have to say, I think the concerns of the committee and witnesses has been less around that particular warrant and the other two than the other two.
I think the other two, as the Commissioner started to set out in his opening statement, put law enforcement in a place that they're able to tackle online crime in the exact way that they're able to tackle physical, real-world crime now.
Yep.
Those laws need to catch up.
Just one final matter for me, and then I'll off the call to Senator Keneally. Another consistent theme of those who had concerns about the bill is the authorising authority, whether it should be, as proposed in the bill, a member of the AAT or a magistrate, or whether it should be a member of a superior court. Why were those authorising authorities chosen? And would there be any operational concerns if a higher authority was required to provide the warrants?
Happy to start on that and pass to the operational concerns. But those authorities are chosen again because they replicate how the Surveillance Device Act and the Crimes Act work. So for the account takeover warrants, there's a range of powers under the Crimes Act, including existing 3LA assistance orders, search warrants that are issued by magistrates. And so the account takeover power seemed to be appropriately placed within the Crimes Act, was given the same authorisation level. Similarly, in terms of all of the kind of relevant surveillance legislation that we're talking about here, whether that be the Telecommunications Interception and Access Act or the Surveillance Device Act, all of those covert kind of collection powers that allow lawful access have been set historically at both the AAT and a judicial officer. So both have been available to law enforcement to apply to. I don't know if you want to...
No, I mean, I think at the end of the day, it's a policy decision in terms of whether you go to a judge or an AAT member or to a magistrate. So we'll obviously play what's in front of us. But I think there's a tone in some of the language that an AAT is an easy person's an easy alternative. We don't find that. We use the AAT personnel on a regular basis, particularly in relation to telephone intercepts, and those affidavits and forms are closely scrutinised in terms of the paperwork we put through that process.
But just to the second part of my question, what operational difficulties would it pose you if a higher level authority was required? I mean, so for example, I guess it depends in part on how often you plan to use these powers. Are you going to be using them hundreds of times a year or just a handful of times a year? And is there going to be any resourcing issues if you're going to need to use this more frequently and therefore have a smaller group of people who can get that authority from?
Like, I think the issue of magistrates in terms of access and number of magistrates, in terms of operational effectiveness, that would provide, it obviously provides benefit, but at the end of the day, it's a policy decision for government. And again, I think I don't want to over-egg the pudding and say this would be disastrous in terms of an operational impact, but I think as the point that Andrew has made, it's very consistent in terms of the powers that we currently have in place.
Okay. All right. I have plenty more questions, but I have to share the time with my colleagues. So Senator Keneally, we'll go to you.
Thank you very much. Thank you to the witnesses for being here. If we could start on this point about magistrates, and I'm just going to note, Mr. Warren, your comment about consistency. There's much to be admired with consistency, but then again, Ralph Waldo Emerson said consistency is the hobgoblin of small minds. So let's just explore a little bit the application of consistency here. The bill proposes to vest authority in magistrates to issue the account takeover warrants, and because it's consistent with the overt powers in the Crimes Act. But is there any reason why this authority isn't vested in eligible judges or nominated AAT members, given that would be consistent with the measures outlined in the Crimes Act, the Surveillance Device Act, the TIA Act, and the proposed data disruption warrants and proposed network activity warrants as outlined in this bill?
Sorry, Senator, I'm just trying to differentiate the question I just got before. I think our answer is somewhat similar, or my answer would be somewhat similar, that we looked closely at the nature of the power, and in determining the nature of the power, determined that it was government determined it was probably best placed in the Crimes Act, and those warrants are generally issued by magistrates. And so we sought to maintain that.
So it's your contention that the account takeover warrants are not analogous to the proposed data disruption warrants or proposed network activity warrants as outlined in the bill?
Absolutely not, Senator, and I think that was the point I was trying to make earlier on in my evidence, that I think they've been cast somewhat broader in the hearing today than they actually are. They are quite a confined warrant, that they only allow the AFP to take over that account, or the ACIC, to enable the collection of evidence, not to actually do the collection of evidence. That has to be authorised under separate powers, whether that be the AFP's controlled operations regime or a surveillance device warrant or a computer access warrant. So they have to work. So it's not the same as those kind of more covert, intrusive collection powers.
And for those who might be watching this in the community, just to be clear, that in order to get those, you would have to apply for a separate warrant.
That's absolutely right, Senator.
Okay. Can we go back to the, so I apologize up front, I'm due in a meeting at about 4 o'clock. I'll be a few minutes late, but I will try to get through some of my questions and note that some other members may want to follow them up. I do want to go to this issue of threshold levels, and what I'm seeking to understand here is not so much the issue between 3 and 7 years, although other committee members may want to explore that. But just note that the bill outlines a number of crimes: child abuse and exploitation, terrorism, the sale of illicit drugs, human trafficking, identity theft and fraud, assassinations, and the distributions of weapons as the examples of the crimes that would be persecuted. What I still haven't heard a convincing argument as to why those categories of offences couldn't be defined in this legislation, because it appears to me, and I reflect on the Deputy Chair's earlier comments to earlier witnesses, we are being asked again to take on face value that this legislation, which we are being asked to support, will not extend to minor offences. What safeguards beyond just pointing to capacity constraints or the good intentions of government can you point to that would assure this committee that these 3 warrants would not be used for other types of crime, other categories of crime, or lower, what would be considered by the community to be lower level offences, perhaps not in the punishment they attract, but indeed in terms of the seriousness of the crime?
Yeah, I mean, Senator, as I noted before, and it has been noted before, we have finite resources. So obviously our resources are focused on the higher end. I'll get to your question.
But I accept that.
Yeah.
That's a legitimate question, but it doesn't actually provide reassurance, given that this committee has heard similar arguments in the past in relation to the TOLA bill.
But I go back to the question, the answer I gave previously. There's safeguards built into the legislation. If you look at data disruption warrant, for example, the issuing officer has to be satisfied that the activities authorised by the warrant are justified and proportionate with regard to the offences being targeted. They also have to look at whether the existence of alternative means of frustrating the commission of offences can be achieved through another way. So, in terms of the, I suppose, the application we put either to in relation to that case to a judge or an AAT member, that gets taken into consideration, Senator.
Yeah, I apologise. I don't mean any disrespect, but I feel like that isn't the type of answer we've heard before in relation to TOLA. I don't find that yet convincing, that we're not going to, in a few years' time, have a review of this legislation and find out there have been warrants issued for a range of other offences simply because they attract a 3-year threshold.
Maybe I could assist, Senator. I mean, if you look at, let's give the example of outlaw motorcycle gangs. For a start, they're called outlaw motorcycle gangs, which means they sit 1% of Australians that don't believe in the laws of this country. They have sophisticated structures now built around a business model, and if you're going to disrupt and dismantle that, these are the types of offences that you'll find within their structures. So, for example, they're that.
What types of offences?
Well, you might have them supplying vehicles, doing all sorts of other offences as part of their logistics arm or their administration arm. You might have offences sitting in with that part of the whole structure, but overall, the criminal enterprise is actually importing drugs, money laundering, whole range of different offences. So it makes it very difficult if you're going to attack the outer perimeter of these organised crime networks. You know, this is part of why this will assist, these powers will assist us to dismantle those networks, especially now
well,
that you can...
Well, in that case, is there some other provision you can put around, or was there some other type of provision or limitation considered, such as the application to an organised criminal network?
Senator, no, I think in terms of what we considered at 27 KM2, we made it the forefront of the eligible judge or nominated AAT member the consideration they have to have under subsection A. So one of their first considerations is the nature and gravity of the conduct constituting the kinds of offences in relation to which the information will be obtained under the warrant. So we've looked at what Parliament has said in terms of objectively 3-year offences being serious offences. That is in existing legislation. But we've then also added additional safeguards to say that's not enough just to go and get a warrant because an offence is 3 years. It has to be of such the nature and gravity in terms of the conduct constituting those offences that information can be sought. And then they have to give consideration to whether the access to that data will assist in the collection of intelligence that is actually then relevant to the protection, detection, frustration of those offences and the intelligence value of that. And then it also has to make sure that things are authorised by the warrant are proportionate to the likely intelligence value of any information sought to be obtained and the existence of any alternate or less intrusive means of obtaining the information. So all of that together makes it very difficult to envisage a circumstance where you could have an offence that is subjectively considered not serious 3-year offence and then still get something like this network activity warrant. There is a range of measures in place for issuing authority to consideration to make sure that that exactly can't happen and that the nature and the gravity of the conduct is forefront.
Mr. Warren, thank you for that. And I appreciate we may just go around in circles here because we may agree to disagree. But my observation is that part of gaining the community's trust and extending extraordinary powers to agencies such as the AFP and the ACIC is ensuring that there are appropriate safeguards in place. And given our experience with TOLA and the community reaction and to the fact that TOLA was being used, despite similar assurances that you're giving me here today, that it's being used for quite low-level offences, it does raise a question to me as to why the government is not willing, if you are upfront in saying we are not going to use these powers to investigate, subjectively low-level offending, why that can't be prescribed in legislation to give the community that assurance. I've heard your answer, though. That is probably more of an observation than a question.
Yeah,
but I think it is
Senator,
an issue this committee has to grapple with.
I'd just like to make a point. I'm happy to take it on notice to provide more granular detail. But in terms of our use of TOLA, it has very much been focused on offences at the higher end. Again, we've used the TOLA legislation as a priority piece of legislation in relation to counter-terrorism and organised crime. So again, we can take that on notice and provide the offences that we've investigated through TOLA, but it has been very much at the higher end, not the lower end.
Sure, and TOLA it's an analogy that isn't perfect. I acknowledge that because other agencies besides you are using it. But we were assured by Department of Home Affairs when we dealt with TOLA that would not be the case, and yet that is the case.
Sorry, Senator, are you referring to data retention rather than TOLA?
Sorry, I am. My apologies. Yes, my apologies.
Confused. Yeah.
Not TOLA. My apologies. You are correct, Mr. Warnes. It's been a long day in these hearings. I want to ask one other question, and then I'm happy to cede time and thank you to the chair for the opportunity to go first. Your submission notes that in some cases a data disruption or account takeover warrant can be internally authorized where there's an imminent risk of serious violence to a person or substantial damage to property. What happens where the warrant's issued in that type of emergency situation, but later on a judge or an AAT member or magistrate don't agree with the grounds under which the emergency authorization took place?
So thank you. In terms of data, that data would be quarantined and it's ultimately still available. And I think one of the submissions raised a question about the availability of the data, and that's actually to then allow subsequent investigation by something like an oversight body as to why that internal authorisation occurred and the appropriateness of that. But can I just say on emergency authorisations, I think everyone realises that these are extreme circumstances and they are used so infrequently and sparingly. They exist across telecommunications intercept, if I'm correct, and surveillance device warrants. And I think there was only one done in 2018-2019 year. And I think similarly, when the annual report is released or tabled in Parliament, for this one there will be very low, if any, numbers. And so I think law enforcement has treated these exactly in the way Parliament has granted those emergency authorisations and used them sparingly, if ever.
But just to go back, what happens to the information that is collected, if any information is collected?
Yeah, it's quarantined. Yeah, so it's quarantined and then it's not destroyed. And again, as I said, some submissions have raised, shouldn't it be destroyed? Because it does say it can be used in a proceeding, but in actual fact, that kind of, the reason for keeping it around is you want to be able to have that information available to then understand what happened, why that might not have been an appropriate use of the powers, and have that, if it's destroyed, the Ombudsman or the I just won't be able to come in and undertake their oversight role. So that's why it's...
And so just to clarify that point, it's quarantined, but we can't use that information.
Yeah.
Right.
So it's not utilised, but it's quarantined for the purposes Mr. Warnes has outlined.
This is an issue that some submitters had raised, so I think that's a useful clarification. Look, Chair, given the time and my need to go to another meeting, I will cede my time here. But I thank, if I can, the witnesses again and acknowledge that the work that they do, particularly when it comes to combating child sexual abuse, is difficult and yet very valuable. And thank them for their efforts.
Thank you very much, Senator Keneally. I'll offer the call to Mr. Wilson and then either Mr. Dreyfus or Mr. Byrne.
Thank you, Chair. One quick point, one quick question, which is to stress the point that Senator Keneally was making about data retention. That is a valid criticism of the data retention regime from a bipartisan sense, and so the threshold of trust is a critical thing that is important for the agencies to address. The question I have is actually with the takeover warrants. In practice, that will enable agencies to go in and to effectively pretend that they are another person. And I'm just wondering, what is the risk of allegations of entrapment associated with a takeover warrant?
So, Mr. Wilson, you've described the scenario very well. So it is basically just a takeover, and for us then to utilise, for us to search and obtain evidence, we'd have to get a computer access warrant, so we'd have to get an additional warrant. But where this power is particularly beneficial for the AFP and also applicable for the ACICs, for us to utilise that account for undercover operations. Now, for us to undertake undercover operations, that's controlled by a separate piece of legislation under the Crimes Act, and it relates to controlled operations and major controlled operations. So if we were going to operate undercover for longer than 7 days, we'd have to get a major controlled operation. And within that, in terms of authority, there's a number of grounds that we need to specify in terms of that additional document, that the nature and extent, and I'll just read out a couple of these for your information, Mr. Wilson. The nature and extent of the suspected criminal activity is such as to justify the controlled operation. Any unlawful conduct during the controlled operation will be limited to the maximum extent possible. The conduct involved in the controlled operation will not seriously endanger the health or safety of any person, cause the death or serious injury of any person, involve the commission of a sexual offence against any person, and result in significant damage to property other than the illicit goods. In terms of what's specified also in the controlled operation is a proviso that we can't, I think you described it as entrapment, that the major controlled operation guards against that scenario in relation to the work that we do. So again, in some respects, the account takeover is the first part, and then subsequent to that, if we need to search for evidence, it's a computer access warrant. But if we want to operationalise that account takeover, we need to utilise that through a major controlled operation. And with that major controlled operation, there's safeguards and provisos in terms of how we operate online.
Thank you, Chair.
Thank you. Either Mr. Dreyfus or the Deputy Chair?
Thanks very much, Chair. Mark Dreyfus here. I first want to raise, I've got questions for all of you there, but I'd like to raise an issue. I think it's an important issue of principle that's raised on the cover of the Home Affairs submission. And it's this, the Home Affairs submission purports to be from the Home Affairs portfolio. And this is a question for you, Commissioner Kershaw. To the best of my knowledge, the Australian Federal Police is still an independent statutory agency with its own Act of Parliament. Is that right?
Yes.
And for you, Mr. Phelan, the ACIC is also still an independent statutory agency with its own Act of Parliament. That's right, isn't it?
That's right, Mr. Dreyfus. It's exactly the same conditions as the AFP.
Yeah, and just to give further content to this, Commissioner Kershaw, do you consider your agency to be independent of the Department of Home Affairs?
Yes, we do. However, when it comes to policy matters, that's where we work with Home Affairs, and they represent our views, and it works quite well.
Well, do you think it's important that your agency not only be independent of the department? I appreciate you work with the department, but do you think it's important that your agency not only be independent of the department, but is seen to be independent?
Yes, I mean, I can tell you right now, our position on this is independent.
Right. Well, I'll go to Mr. Phelan. Perhaps I could ask you the same question. Do you think that your agency should be independent of the Department of Home Affairs, and do you think it's important that your agency not only remains independent of the department, but is seen to be independent?
Yeah, absolutely, Mr. Dreyfus. I mean, our organisation operationally is completely independent of the Department of Home Affairs, and indeed ministerial for that matter. But when it comes to issues of policy, we work very closely with the department, and from time to time we are involved in joint submissions, and as you know, sometimes we have separate submissions that are not dissenting but a little bit different from what is put forward from the department. So in this particular case, when we're looking at this submission, we had a lot of input into the decision, and there's nothing in there that we disagree with fundamentally.
Well, it's something I'd encourage, that you make separate submissions. This is a question for Deputy Secretary Patterson. The Department of Home Affairs is a Department of State and consequently is subject to the direction of the Minister for Home Affairs. Is that right?
Yes, that's correct.
And the same cannot be said, I hope, of the Australian Federal Police, can it? And it can't be said of ACIC either.
Not for the purposes of for operational purposes.
Right, and well, not for any purpose. The AFP and the ACIC are established by Act of Parliament, and the relationship between those two agencies and the Minister for Home Affairs and the government more generally is governed by their statutes. Is that right?
Yes.
I'm concerned, and I'm confident that other committee members are concerned too, about not only preserving the independence of the Australian Federal Police and the ACIC from the government of the day in substance and as a matter of law, and be it independence from the current government or any future government, but also about ensuring that the AFP and the ACIC are always, at all times, perceived to be independent from the government. And frankly, I don't think that a submission like this helps when it comes to that perception issue, which says on the cover, Home Affairs Portfolio Submission on the Slade Bill. Whose idea was it to provide the committee with a joint submission like this?
It's a Good question, Mr. Dreyfus. I think I may well have suggested that we do a joint one. I think you've got to, the policy comes up from operational experience, so it's really important for us when we're explaining the policy to the committee to be able to make sure that we're showing the operational need for this, and we work, as I think Commissioner has said, hand in glove with them in developing this policy, consulting extensively to make sure it meets their operational needs, because ultimately they're the ones going to be using it out in the field. And so we often ask them to do joint submissions with us because it is meant to represent the portfolio. Now, of course, they will, as ACIC has mentioned, Mr. Phelan, say that they will do separate submissions as well, and indeed in this case the AFP put in an additional separate submission, as I understand it, to the committee.
Yes, they did. I can only speak for myself on this, but I don't think it's appropriate for the Department of Home Affairs to make a submission to this committee that purports to be on behalf of the Home Affairs portfolio. At the very least, it's a bad look, because I'm concerned that a submission from the Home Affairs portfolio, your term, obscures an absolutely fundamental distinction between an independent statutory agency and a Department of State. Perhaps I'll ask you this question. The Minister for Home Affairs could essentially dictate the Department's submission to this inquiry, couldn't he? Ms. Patterson?
These submissions are done as a submission from the department, not a submission from the minister per se.
Well, I'll ask the question again. The Minister for Home Affairs could essentially dictate the department's submission to this inquiry, couldn't he?
Not quite sure, Mr. Dreyfus, in terms of dictate. Is that a reference to the? I mean, obviously,
your minister could tell you what to put in the submission, Ms. Patterson.
I guess the minister could advise, but in the end, the submission is a submission from the department, and in this case, was intended to provide further advice to the committee.
I'm not asking you what you intended. I'm concerned here, as I hope I've made clear, by the appearance of this submission. So I'll go to a different point. Whether you're tripping up or not over the Minister for Home Affairs being able to dictate the department's submission to this inquiry, it absolutely is not the case that the Minister for Home Affairs could dictate to the AFP or ACIC, could he?
No.
And I want to be even clearer. Does the Department of Home Affairs believe that it somehow represents the AFP or ACIC? When the department speaks, does it believe that it's speaking on behalf of the AFP, ACIC and the other multitude of agencies within the Home Affairs portfolio?
I think when we do a submission like this, Mr. Dreyfus, we don't speak on behalf of them. We make sure all agencies agree to the position that's put in the submission, and it truly is reflective of all agencies' views. And if agencies have different views, they put in separate submissions or don't concur to having a portfolio submission, as does happen from time to time. But what we do try and do is reflect that we've worked with these agencies in a policy sense to make sure it meets the operational needs of our portfolio agencies.
I think it's also useful, it's Rhys Kershaw here, sir, to note that within the AFP Act is our ministerial priorities, which are settled by the Minister and in conjunction with the Secretary of the Department. So we do consult widely on what our priorities are with the Secretary and the Minister, and we've just settled on some new ones which have been published now and agreed to, and this sits with our current bill about what and meets our abilities, or assists us with our abilities to meet those priorities as per our Act.
But in all other respects, other than that priorities point you just raised, Commissioner Kershaw, the Minister doesn't have a power of direction under your Act over your day-to-day activities. He doesn't have a power of direction over your submissions. He doesn't have a power of direction over your operations.
That's correct.
Yeah. Look, given time's limited, I'll leave it here, but I would invite each of you to think about the concern I've just raised and consider for the future whether it's appropriate to have a submission that is entitled Home Affairs Portfolio Submission. And I'll leave it there, and I'll turn to
and Mr. Trevor, just before you do move on, the point you've made is very clear and well articulated. I think equally the committee would also have a concern if departments were making submissions to us where they did not consult relevant agencies within their portfolio and did not reflect the feedback of agencies in their portfolio. We might accuse you of not having done sufficient due diligence if you did that. So in concert with what Mr. Dreyfus has asked you to do, I would also ask you to make sure that your submissions do reflect the accumulated wisdom within your portfolio and not just your own views.
Yes, thanks, Chair. Now, I've got just a couple of questions for Mr. Phelan. They're ACIC questions. According to paragraph 38.31 of the Richardson Review, the ACIC made no submission to Dennis Richardson requesting threat reduction or disruptive functions or powers to be included in its legislation. It's also the case that ACIC has not made any separate submission to this inquiry making the case for why it should have the data disruption warrant power. Can you tell me whether ACIC even wants this power?
Certainly, Mr. Dreyfus. Nothing that we do in our organisation, as you know, is done basically off our own bat. So we work collaboratively with all of our partners, including the AFP. So the operational structure that we will set up to use a lot of these powers is done in concert with others. Now, sometimes that will be off our own motion, sometimes it will be off the AFP's, but certainly a power like this vested in the ACIC is one that is sought by the agency as well, because there are occasions when we may choose to initiate the action ourselves across all three, in particular in relation to network activity warrants.
Well, no, I'm specifically concerned with the data disruption warrant power.
Well,
and I'm intrigued by this because Mr. Richardson's gone to the trouble of recording the fact that you didn't ask for it when he was considering this very point in his lengthy and exhaustive and comprehensive review. Perhaps I'll ask this: why didn't the ACIC make a submission to Mr. Richardson requesting or making the case for a data disruption warrant power?
Look, Mr. Dreyfus, I can't actually recall back at the time why, as a policy decision, the agency didn't do that. But at this particular time, as it's been articulated before the committee, the data disruption warrant is very narrow in terms of basically effectively gaining access so that then other lawful powers that are also available to the Commission, because as you know, as a law enforcement agency, all those other powers to gather evidence under computer access warrants, surveillance devices, telephone intercepts are all available to our agency. So what would effectively happen would be for our operations, which are similar to AFP operations and those of other law enforcement agencies, we wouldn't have the key to the front door that others would effectively have at their possession, namely the AFP.
In what sense is the data disruption power narrow, Mr. Phelan? And I'm looking, for example, at section 27 KE7, the proposed new section 27 KE7 of the Surveillance Devices Act, which envisages that there could be a data disruption warrant applying to a large telecommunication facility. And it might theoretically be necessary to disrupt all the data held in that large telecommunication facility. I'm just curious as to why you describe it as narrow.
Narrow in the sense of obtaining content data. as I think Mr. Warnes might have talked about earlier on.
This is the data disruption power.
Oh, sorry, I thought you were talking about the account takeover. Sorry, Mr. Dreyfus, sorry.
Anyway, I'll move on. Why didn't ASIC make a submission to this inquiry, which the AFP's made a separate submission?
We've certainly concurred with the matters that have been put forward by the department and also the AFP. So, in terms of separate...
But you've got... I'm asking Mr. Phelan because you've got different functions to the AFP, and you've certainly got different functions to the department.
We do, and if there are certain activity that we would like to disrupt under these warrants that, quite frankly, I don't want to articulate in this room, happy to do in a different security classification setting, but it clearly fits within what our agency is set up to do. I mean, if I can just give that a little bit of context, Mr. Dreyfus, as you're aware, our organisation only works on serious and organised crime because that's our mandate. That's where the board sets, the board has to set the determinations under which we operate, and one of the thresholds for those is serious and organised crime. Serious and organised crime at the moment operates like a business. There are where communications to them is an essential part of their business model. At the moment, we have a very significant gap in law enforcement in tackling serious and organised crime due to encrypted networks. These criminal networks are currently operating, for example, in Australia on dedicated encrypted devices, of which we estimate there may be just over 10,000 in this country. These devices cost anything up to $5,000 each and around $5,000 a year to run. You do not have one of these devices unless you are a criminal. Well, a couple of them might be in the hands of journalists for their own research.
Yes,
but
right.
Having said that, these networks, operated by criminal networks, are something that is different to what we've been able to tackle in law enforcement in this country up until this time, or right now, as a matter of fact, before the bill. Traditionally, we may know who has done something, or we might know what somebody has done. And if we're lucky enough to know the who and the what, we use electronic surveillance that we currently have under TI, surveillance devices, search warrants under the Crimes Act, all sorts of other covert and overt investigative powers. But when we do not know the who nor the what, we have a very significant gap. And this is where we use components of the TOLA legislation to help us work with telecommunications companies and etc. to help discover the networks that are available. And now this piece of legislation will enable us to get on those networks to, if this is in relation to the network activity warrants in particular, it is a very large gap that we need to fill because we just are flying blind in relation to over 10,000 devices. These servers, some of them held offshore, some of them held here domestically, we simply don't know. This is what we need to be able to get inside these networks to help disrupt the criminal activity that's involved in relation to those particular activities. And if I can just go back and we look what happened in Europe last year when EncroChat was taken down, which is what I'm talking about, dedicated encrypted networks where the devices themselves, you can't make a phone call, you can't access the internet, you can't do anything with them. You can't browse, you can only send text messages and maybe photographs. Those networks that were taken down in Europe, when they got hold of the servers and found out the abhorrent crimes that were involved, that they were able to take down in France, Belgium, other parts of Europe, the United States, Australia and the UK, just goes to show the level that organised crime will go to encrypt, disguise, make anonymous who and what they're doing so that they can perpetrate their crimes. This is what we need to be able to have access to. It's hard for me, I could bang on about this all day. This is an absolute gap and something we do need to address. Otherwise, it's only going to get worse.
That was an eloquent explanation, if I can say so, Mr. Phelan, that explained very clearly, I think, for me and other committee members, the justification for network activity warrants, possibly even account takeover warrants going to ACIC. But this bill proposes to give 3 new powers to ACIC, data disruption warrants well as network activity warrants and account takeover warrants. And I'll see if I can cut this short, Mr. Phelan. What I would appreciate is ACIC providing the committee, it doesn't need to be long, with a separate submission outlining why these 3 powers are needed for ACIC. And in addition, because I don't have a submission from you yet to work off, what sort of internal mechanisms and process the ACIC has in place to ensure that the powers are exercised appropriately.
No problem. No problem with that.
Thank you very much, Mr. Phelan. If I'm not, otherwise we'll take up. I know you can talk about this for a long time, and I can listen for a long time, but we've only got about half an hour to go.
I may be able to cut it a little bit short too, just so I finish off what I was saying. Is the issue about data disruption is that a disruption for us is also an option when it comes to mapping the networks. So once we've got hold of the networks, we may need the tools to be able to disrupt them that we currently don't have at the moment. So we may just want to do something to those networks similar to what they did in the UK, France and others. So those are the sort of powers that would be gained from those particular provisions. But in terms of doing further than a submission, I'm more than happy for you to come and have a look at what we've got to and what we intend to do. I think sometimes seeing it visually might be a little bit better.
Thank you for that offer, and it may well be that not only I but other members of the committee might be interested in taking up the invitation. So we'll park that for the moment, but look into it. Thank you. If I can, I'm indebted to you for that offer, so I'll leave that there, and I'll turn now to the department with a question that goes to a previous report of this committee. Last year in its report, the Press Freedom Report of this committee, we recommended that the current role of the public interest advocate, as provided for under the Telecommunications Interception and Access Act 1979 for the purposes of journalist information warrants, be amended and expanded to apply to all warrant-related provisions that could relate to journalists in a number of other acts, including the Crimes Act and the Surveillance Devices Act. The government's formal response to that recommendation, which was recommendation 2 of our report, was to agree to that recommendation. Curiously to me and other members of the committee, this bill, which would introduce 3 new warrant-related provisions into those same acts, does not require mandatory consideration of warrant applications by a public interest advocate where such applications relate to a journalist. And my question is simply, is this a mistake?
Mr. Dreyfus, it's not a mistake. We're well aware of the committee's recommendation and are actively considering how best to implement it, not in a piecemeal fashion, but in a way that holistically addresses it across all of the legislation that the committee recommended. So in the interim, we also had the Richardson Review that you've referenced, which also recommended holistic reform to this legislation. So we are considering how best to do that and considering how to implement some of the Richardson recommendations alongside some of the committee recommendations that we've got from reviews such as that one that you mentioned.
Why doesn't this bill implement the committee's recommendations? We're talking about introducing 3 new warrants. The government had the committee's recommendation from its previous report. The government agreed with the committee's recommendation in the previous report, and is now putting before the Parliament 3 new powers, but is ignoring the government's own agreement to the committee's previous recommendation. And I'm puzzled by this.
Mr. Dreyfus, I mean, I wouldn't characterise it as ignoring the recommendation. As I've said, we're giving it active consideration.
Well, Mr. Warren, stop there. Why wouldn't you characterise it as ignoring the committee's previous recommendation when the government is putting a bill before the Parliament which does not incorporate the committee's recommendation from its press freedom report, despite the fact that the government agrees with it? It looks to me like ignoring.
As I said, we're working our way through actually being able to implement it holistically across all of those acts that you mentioned, not just inserting it into 3 new warrants, but doing it in a way that is consistent with the committee's recommendation and make sure it works appropriately and is adapted to all of those different legislative regimes.
Can I take it that the government, given that it has agreed to the committee's previous recommendation, would not object to the committee recommending that the bill be amended to implement the recommendations that the committee made in its press freedom report?
I don't think it's for me to comment on what the government would or wouldn't object to. As you're correct in stating, the government has agreed to that recommendation.
I'll move on. The Law Council noted in its submission that proposed section 27KA1 would allow any law enforcement officer to apply for a data disruption warrant, even the most junior officer in a law enforcement agency. And the same is true in respect of account takeover warrants. Having regard to what most witnesses before this committee have described as the extraordinary nature of the data disruption warrant power, in particular, would a junior AFP officer or an ACIC officer, junior ACIC officer, ever in practice apply for one of these warrants?
I think I can assist with
That's
possibly...
the question for Commissioner Cush or
Mr.
Deputy
Dreyfus,
Commissioner McCartney.
Yes, and I'll probably hand over to the Deputy. But internally what we would do is, if it was a junior officer, that would go through a supervisor and likely have to be cleared by a superintendent or a commission officer in our internal policy. So it would be an internal guideline for us. We wouldn't, given the fact that you're committing, serious resources to this, it's like our search warrants. We have a process where if a junior officer is seeking a search warrant, it has to go through a supervisor because there are resource implications, operational, et cetera, et cetera. So I don't know if the Deputy, if you want to add anything to that.
Yeah, so, Mr. Dreyfus, we acknowledge we're entrusted with these powers, which some of the powers are obviously significant, but just letting on from what the Commissioner said, in terms of those powers, we have set governance and set procedures within the AFP, and I'll draw the analogy or the example of a major controlled operation, which I mentioned before, which is long-term deployment of an undercover operative in terms of a long-term operation. So a case officer or a constable would make that initial application, but in terms of the governance, this is set governance in terms of how that paperwork's reviewed and passed up the chain of command, and those sorts of documents would be signed off and are signed off at the Deputy Commissioner level. And we envisage giving these proposed powers. Firstly, there would be a set internal governance that we'd put in place, and secondly, there would be sign off at a significantly high level within the organisation.
Just to get this clear, Mr. Phelan, is ACIC in a similar position that this has got to go to some more senior level from a procedural point of view within ACIC?
At a procedural authorisation level, yes, but application level, Mr. Dreyfus, it's like even telephone intercept warrants, etc., all different levels of the organisation. It's the authorisation internally to go ahead with the process, and then, of course, most importantly, where it's authorised to actually do it by the AAT or the judicial officer. That's far more important than the rank of the officer that applied, in my view.
Well, I'm reassured to hear that both the AFP and ACIC have internal processes that mean that some level of seniority is going to be needed with authorisation, but to go ahead. Yeah. But why should this legislation require why do you require to have in the legislation what to me looks like an extraordinary degree of flexibility, empowering even the most junior officer in both your organisations to apply for an extraordinary data disruption warrant?
I wish I was doing the investigation, but I'm not. Those junior officers are undertaking the investigation at that coalface junior level, Mr. Dreyfus. So they're living and breathing the job. They're compiling the information and evidence that's required for these types of warrants and these types of powers. But as I've stated, there's a set governance process within the AFP and also obviously the ACIC in terms of adjudication, oversight and review. It's particularly important.
Sure. But I think we're at cross purposes here. No one's disputing that junior officers do the hard yakka of the investigative work and they're the people with all of the information. But this is a piece of legislation that empowers the most junior officer in both your organisations, without more, to apply for one of these warrants. And I'm asking you to explain why it is that the legislation needs to provide in that way, whether there would be any difficulty if, even if only for the purpose of providing confidence to the Australian public, the legislation restricted applications to a more senior level in both your organisations.
Mr. Dreyfus, it's Mike Phelan here again. Like I said before, I don't think it's a matter of the level of the person that's making the application. It's more where the authorisation is given. But having said that, though, some of the case officers themselves are those that are best placed to answer the questions of the authorising officer rather than going up through the chain of command to, say, get a superintendent level or the equivalent in my organisation or above to answer those questions to the authorising officer may have when they'd only have to defer.
No, I'm not, again, we're at cross purposes. I'm not suggesting at a practical level that there won't be junior officers involved in an investigation, and nor would I dream of suggesting that that junior officer shouldn't be present to answer questions from the issuing authority if they've got any questions. This is about the appearance of the legislative scheme and whether or not it would be much more appropriate to have a more senior level of person required to sign off, that is, a more senior person within your organisations, both AFP and ACIC, on the face of the legislation being required to sign off before an application is made. You've both told me that internally that's what you do and would do, and I'm wondering why the legislation shouldn't say so on its face.
Sorry, Mr. Dreyfus, I caught the last bit. Are you saying there should be some? I missed the last bit. Are you saying there should be some additional requirement about not the actual application, but the sign off to go and apply?
At the moment, this bill provides for the most junior officer in both the AFP or ACIC to make an application. In other words, the external face of ACIC and the external face of AFP could be the most junior officer in in both organisations, applying for what everyone has seemingly agreed are extraordinary warrants. What I'm getting to is what the legislation requires to be done.
I think, Mr. Dreyfus, it's Rhys Kershaw here. You may open up a can of worms in the sense that you may have a sergeant who's actually less experienced than a senior constable or a constable. You might have a 25-year veteran who's a detective constable and never wants to go anywhere from a rank point of view. You could classify them as a junior officer, but they're actually probably more experienced than the sergeant. So we don't just have rank and the junior bit sort of attached to that. There's very experienced officers who would be very perplexed as to why they can do a search warrant on any premises in Australia and apply for that, yet they can't apply for a data disruption warrant.
And Mr. Dreyfus, can I just jump in and ask a clarifying question here? Presumably you have internal approval mechanisms. Junior officers are not just marching off to the AAT or a judge to ask for warrants.
That's right.
What approval do they have to seek from more senior officers within the AFP?
So it has to be adjudicated. We have internal processes that go to a rank officer to make those calls. For one is you can't even go to that issuing authority or issuing officer without going through that process. So it has to be adjudicated, the resources have to be allocated, the costings of what this investigation or matter are going to apply, the resources, specialist resources required. There's a lot that goes in before you'd actually make this application. And it may even have to go beyond that, as the Deputy said, to something like our Sensitive Investigation Oversight Board, which is chaired by 2 deputies, before they even can step on the field and undertake this activity, because it's a serious activity, and we would be looking at that through that lens.
And I 100% agree. It's Mike Phelan again. I 100% agree with Commissioner Kershaw on this, and I'd just like to add that it's the most appropriate person that has the information before them to put before the authorising officer, and that is not a function of rank. That's a function of knowledge.
And again, I'm not. Perhaps I'll ask this a different way. Who has to apply for a network activity warrant?
So the network activity warrant has been lifted up to a more senior level because of the intelligence collection nature, Mr. Dreyfus. So that was determined appropriate, given the limited number, I think, as well.
Can you answer my question? Who has to approve who has to apply under this bill? Who is required to apply for a network activity warrant?
So it can be the AFP Commissioner or the Chief Executive Officer, and it is delegated down to senior level officers in each organisation.
Right. Just pause. So pause there. That's my point. I wasn't debating with you that junior officers have got knowledge. It's that for the purposes of assuring the public that senior and appropriate consideration is given to the correctness of applying for these extraordinary warrants, what practical problem would there be in requiring for the other 2 types of warrants, the data disruption warrant and the account takeover warrant, there being a similar level of seniority required as for a network activity warrant?
Commander for the network activity. I'm not sure I can add too much more, Mr. Dreyfus, to what the Commissioner has said. I mean, once again, these powers look to replicate some of the other covert powers and how applications for those warrants are used, so it's consistent with those. As we said, I think we acknowledge the network activity warrant goes a little bit further in terms of intelligence collection and has less specificity as to targets, and so therefore was deemed appropriate, given again it's kind of a warrant that we expect to be used less, and kind of that exploratory intelligence collection to have a more senior application there. But I understand your point as well, Mr. Dreyfus.
Well, it was a question actually, Mr. Warnes, and that Hansard will record that you've declined to identify any problem that would arise if a more senior level of authorisation were required.
Sorry, Mr. Dreyfus.
I'll move on to my next.
Sorry, Mr. Dreyfus, please allow Mr. Warnes to.
Sorry, can I just
add to that?
Just add, Mr. Dreyfus? I think what I said was that I had nothing to add to what the Commissioner and I would also add to what Mr. Phelan said.
And they haven't identified a problem either. So that's why I've said, as a characterisation of this exchange, that Hansard will record in full that you haven't identified a problem. I want to go to something else.
So,
that the Law Council...
Mr. Dreyfus, just for time management purposes, I think it's only you and I who have further questions for these witnesses. How much more time do you think you will need, noting that we were due to conclude at 5 p.m?
10 minutes.
Okay.
Depends on how quickly people answer.
I think I probably only have 5 or 10 minutes as well. So can I have the witnesses' agreement that we go a little bit over time? I won't keep you any longer than that. Thank you. Okay. Please continue, Mr. Dreyfus.
Thanks very much. The Law Council pointed out at paragraph 33 of its submission, still on this question of who's to make an application, that a law enforcement officer could authorise another person to make the application on the officer's behalf there's no requirement in the legislation that the other person even be a staff member of the AFP or the ACIC. Does that mean that a junior AFP officer, and under the bill as it stands, for the data disruption warrants and the account takeover warrants, could authorise another person, could be anyone at all, to make an application for a data disruption warrant? And if that's so, why is that flexibility needed?
I'm looking at the AFP. I might start and then get people to jump in to correct me. But I think my understanding of the way the application for these warrants work and why you have that additional person is when it refers to sworn officers, I imagine there might be legal staff and unsworn people who could potentially make the application on their behalf. But I'm looking at...
That's correct. Mr Warnes is correct on that.
Why do you need that flexibility? I mean, perhaps I'll contextualise this. This goes back to something the Chair asked about at the start and has asked other witnesses. We're assuming that we're not going to have thousands of these warrants or even hundreds, that the scale of activity by the agencies under using these new warrants is more likely to be in the dozens, a bit similar to the scale of activity under TOLA. And obviously, if there were thousands of applications for these warrants, there might be a different administrative burden proposition that you would speak to. But am I right in assuming that it's a relatively small number of these warrants that both the AFP and ACIC have in mind?
I think that's correct. I think computer access warrants are probably some guidance which were introduced, as you would well know, Mr Dreyfus, in the TOLA legislation. It's probably a guide where you're talking about in the number of low teens to 20s at the moment, I think, in terms of usage. So I'd say that's correct. And the people at the table are nodding.
Sorry. Why do you need the flexibility of being able to have a junior AFP officer authorise another person who may not even be employed by ACIC or the AFP to make an application for a data disruption warrant?
I think as I've kind of repeated, and I apologise for repeating myself, Mr Dreyfus, but we've reflected some of the other warrants frameworks in the Surveillance Devices Act, computer access warrants, which were only introduced 18 months to 2 years ago, also have the same application process and the same criteria as to who can apply.
Thanks. I'll move to another point. In the Home Affairs portfolio submission, you've argued that the proposed new powers are proportionate to the identified risk. And the risk that's identified in the submission, and I'll quote, is activities that have a direct and real impact on Australia's most vulnerable, and end quote, and then elsewhere, quote, are usually orchestrated by the most sophisticated of criminal networks, end quote. But the risks identified in the bill itself would include the risk to the community presented by, for example, bigamy, that's Section 94 of the Marriage Act, or the alteration of trademarks without permission, that's Section 15 of the Trademark Act, or another one, obtaining cheaper internet dishonestly, that's Section 474.2 of the Criminal Code. And I want you to think about this. Are the proposed new powers proportionate to the risk to the community that's presented by people engaged in bigamy?
I think, well, from an AFP perspective, I mean, we target criminality, as you know, and what I was trying to articulate previously was that the criminal networks that we see online now, they commit a number of different offences, and collectively it equals serious crime, serious and organised crime. So that's where I think for us, we may not necessarily just target bigamy. For example, we'll be targeting the network and how they're operating online. illegally.
But my question goes to the formulation that appears in the Home Affairs submission, which is putting the proposition about the proposed new powers being proportionate to the identified risk. And I'll ask you about the other two as well. Are the proposed new powers proportionate to the risk to the community presented by people who altered trademarks without permission? Are the proposed new powers proportionate to the risk presented by people who are obtaining cheaper internet dishonestly?
Mr. Dreyfus,
I don't think the question's answered with respect by you pointing to criminal networks.
Mr. Dreyfus, I think I'd refer you to the evidence I gave previously and the evidence you've heard earlier today from Mr. Zernzak, I think as well, about the importance of having a breadth of relevant offence captured. Parliament has sought it fit to have these offences with 3-year penalties. They did that, one can only assume, knowing that a range of these powers were available. As I said, these powers, in some cases, the account takeover power using a 3-year offence will then be necessary to then use other covert powers which also have 3-year offences. So
Mr.
we
Warnes,
absolutely
these are
think
new
it's
powers which the Parliament, I will interrupt you, these are new powers which the Parliament is being asked to consider with this bill.
Yes.
And your department has put forward the proposition that the proposed new powers are proportionate to the identified risk. Some of the risks, by definition, which this bill extends the powers to, include bigamy, altering trademarks without permission, and obtaining cheaper internet dishonestly. And I'm asking how it is that powers which many witnesses have described as extraordinary are proportionate to those offences.
Mr. Dreyfus, as I was explaining, these powers exist right now in terms of computer access warrants, the ability to go and get a warrant for that same level of offence. And the other thing I would say...
Mr. Warnes,
sorry,
I have
can I
to
just
stop you. No, Mr. Warnes, if you could let me just direct your mind to my question. We don't have at the moment a data disruption warrant. We don't have at the moment a network activity warrant, and we don't have at the moment an account takeover warrant. This bill creates those powers. So referring me to existing powers doesn't actually answer the question.
So I'm still trying to answer the question for you, Mr. Dreyfus, and referring you to the fact that not only is it a relevant offence threshold, but there are a range of other thresholds to ensure that proportionality. So when you look at, for example, 27KM2, as I pointed Senator Keneally to earlier, in determining, for example, whether a network activity warrant should have been issued, the eligible judge or an AAT member must have regard to the nature and gravity of the conduct constituting the kinds of offences in relation to which the information will be obtained under the warrant. So there's a proportionality test right there. In subsection 2D, it also goes whether the things authorised by the warrant are proportionate to the likely intelligence value of any information sought to be obtained. So absolutely, I would say, Mr. Dreyfus, any time you get one of these warrants, you have to consider proportionality, you have to consider the nature and gravity of the conduct, and that's irrespective of the nature of the actual threshold maximum penalty of the offence.
And can I suggest to you, Mr. Warne, that you haven't answered my question. You've instead pointed to another part of the bill which invites the issuing authority to consider proportionality. The department's submission did not refer to that. The department's submission put a very direct assertion that the proposed new powers of themselves are proportionate to the range of risks that they are available for. And I haven't heard you answer my question yet, which is, I'll repeat it, are the proposed new powers, that's these 3 new warrants, proportionate to such risks as engaging in bigamy, altering trademarks without permission, or obtaining cheaper internet dishonestly?
I'm not sure there's anything further I could add, Mr. Dreyfus, to the answer I've given.
That's fine, leave it. This is a question for Deputy Commissioner McCartney.
And it might have to be the last one, Mr. Dreyfus, given the time.
There's a little set.
last topic then.
Deputy Commissioner McCartney pushed back against a suggestion that was made to him that it's somehow easy to get a warrant from the AAT. This is actually quite a long-standing concern of mine. And it's a concern because according to evidence provided by the AAT to Senate estimates in late 2019 and early 2020, the average length of time it takes an AAT member to consider warrant applications under the Telecommunications Interception and Access Act may be as short as 18 minutes, and in one case, possibly as short as 1 minute. And I'd ask you whether does that sound like it's difficult to obtain a warrant from the AAT? Well, if you can get a warrant in 1 minute.
I'm not aware of the evidence, but from experience, and in terms of my engagement with AAT members, that hasn't been the case. I think the other issue, Mr. Dreyfus, in relation to a number of warrants we've obtained, obviously when we get to the stage where we bring these matters to the court, those warrants are vigorously challenged by defence in terms of whether they're legally correct. So we would challenge through that process too.
Well, that's if there's review sought after the issuing's occurred. There's a similar answer that was provided to Senate estimates about warrants under the Surveillance Devices Act. They take slightly longer on average, according to these answers, 24 minutes, but it's also potentially as short as 1 minute in some cases. And again, I'd say, does that sound like it's difficult to obtain a warrant from the AAT if, in at least one case, a warrant's been issued in 1 minute?
Senator, I'll just go back to my previous answer. Again, I'm not aware of that evidence, but from my personal experience, that hasn't been the case.
And just going to the justification about AAT members being legal practitioners, the AAT has told Senate estimates that there's a nominated AAT member for the purposes of the Surveillance Devices Act who was not enrolled as a legal practitioner of the High Court or of another federal court or the Supreme Court of a state. Do you think it's appropriate for an individual with no legal qualifications to issue any of these 3 warrants that are in this bill?
Yeah, I think, Mr. Dreyfus, it's Rhys Kershaw. That's really a matter for the AAT.
No, it's not. It's a matter for the Surveillance Devices Act uses the phrase nominated AAT member.
Mr. Dreyfus, we're aware of that issue and aware of that error on the face of the Surveillance Device Act, and I'm happy to correct this on the record if I get it wrong, but my recollection is the IPO bill that's currently before the Parliament actually has a fix for that to correct that error. So we are aware of that and looking to correct it through legislation that's been before Parliament, is in Parliament, has been heard by this committee.
Well, I'll be very pleased if that's the case, but
Yep.
do you think that that's a matter that should have been drawn to the committee's attention in the Home Affairs portfolio submission, if it is in fact the case?
I'm sorry, Mr. Dreyfus, I can't recall if it was set out, whether it was in the explanatory memorandum to the legislation in the case the IPO bill or the submission. I just can't recall.
Well, if you could confirm in writing for the committee, because it's an important matter and it goes to just who is to issue what, as I've said, many people have described as extraordinary warrants.
Yeah, absolutely happy to take that on notice and provide you some more information on the IPO bill and the fix that's there.
I did have some other questions, Chair, but I think they can go on notice. We can deliver them in writing.
Thank you, Mr. Dreyfus. I'll be grateful for that. I just have a couple of one final topic and one clarification. The clarification just on this issue of relevant offences. I notice in the definition, the relevant offences, there are 2 different fisheries acts which are specifically mentioned as being within scope of relevant offences. What's the purpose of that? What's the rationale for that inclusion?
I don't think they're specifically mentioned. I think people might have given them as examples of Commonwealth offences that carry 3 years. I'm not even sure if the AFP investigates fisheries offences, or whether that's a separate body like AFSA or someone who has investigatory authority for some of those Commonwealth offences. And I guess that's one of the points that's worth making. These powers are specific only to AFP and ACIC, who tend to focus on serious crime, as both the Commissioner and the CEO.
Okay, so I'm reading here from the definitions section 6 of the SD Act. So perhaps this relates to previous powers, not the new powers, and it lists a range of things, including the 3-year threshold, and among it is the Fisheries Management Act 1991 or the Torres Strait Fisheries Act 1984.
Yeah, apologies. I
That's
thought
right.
you were referring to our legislation amending bill. I don't have an answer as to why that was there. I assume previously in the regime it was thought appropriate to put it in there for surveillance devices,
But am I right in understanding that if this Act was amended according to the draft bill,
it picks up the definition
that
in
it
the
would pick up
current
those
Act,
definitions?
so that's correct. Chair.
I would be very interested to know how it could potentially be used in the enforcement of those two acts.
As I think I was saying, I'm not sure it could be used in the enforcement of these acts because the AFP don't investigate those offences.
Right.
Only the AFP can use those powers.
Okay. Well, if that's your answer, happy to accept that.
I'm happy to look that on notice and see if there's any correction to that, Chair. But
thank you. That'd be good. Okay. That was the clarification, and then just one final kind of topic to pursue. Ms. Noble, thank you for patiently joining us here today. One thing which we haven't really discussed today is ASD's role in assisting the AFP should this legislation pass. So I'd be grateful if you could just briefly outline how you see how the ASD would be involved.
Absolutely. Maybe just to start to be very clear that this bill proposes no changes at all to ASD's functions or any of its powers or capabilities. We have two functions which are set out in the Intelligence Services Act, under which we can explicitly provide support to the AFP and ACIC in these sorts of matters. One is an ability to provide technical advice and assistance to any Commonwealth or state authority, which is something that we actually do today and work often in collaboration with the AFP and the ACIC and assisting them with respect to their work under their functions and their authorities and capabilities. Secondly, and probably more directly pertinent to this bill, in 2018 ASD was given a function to enable it to prevent and disrupt cybercrime undertaken by people or organisations outside Australia. So just to be very clear how that works in an operational sense is that we can deter, disrupt, gather intelligence on, build an understanding or appreciation of how cyber criminals are acting unless we form a reasonable or make a reasonable assessment that that activity might involve an Australian person or be being conducted from a computer or network inside Australia. So if our operational staff form that view, then they will immediately stop work. So at the moment, and I'll give you an example perhaps that might lend colour to this. If we were working on that basis to disrupt and deter cybercrime, we formed a reasonable assessment that an Australian or an Australian network might be involved, we stop. If that activity is at a point of still needing to gather intelligence on, understand the capabilities and or take some action to disrupt, then we would stop work and be unable to hand that operational activity over to either the AFP or ACIC, which does actually in real life occur, in which circumstance ASD officers are in a position of watching crime happen to Australian victims sometimes and not be able to hand it over anywhere. So our experience, and I'll give you an example, last year as COVID was frightening people around the world, criminals started to understand that that was an attractive way for them to gain people's attention. ASD was able to discover a significant organised crime ring, if you like, for want of a better word, and they are highly sophisticated, and some of my colleagues have talked about that today. They operate in marketplaces, it's well serviced, it's 24/7. You can go on there, you can buy malware, bad source code that would help a criminal, if they get it onto your phone, then be able to gather keystrokes and things from your phone. So what they're after then is being able to watch or gather the information as you log into your banking institution, for example, and the average harm for every Australian that occurs to, they lose between an average of $5,000 to $6,000 when they're a victim of that kind of crime. So this was an entirely foreign syndicate. First of all, we had to understand how they were operating, understand how they were organised, work out who was actually in control or where it was being controlled from, understand how we might be able to position ourselves to get copies of the malware so that we could understand how it was working from a technical point of view, which then assists us to be able to disrupt that malware and or the organisation of this syndicate. We did try at first, working with some of our telecommunications providers to block that activity one IP address at a time. But you can't sort of fight this kind of sophisticated organised crime, almost sort of one victim or one IP address at a time. We have to have the capability to disrupt it at scale and go after the syndicates to take the syndicates out. That's what we were able to do. There were thousands of people around the world who had had that malware downloaded on their phones. We were able to assist them, but in the context of where that malware may have been on an Australian phone or an Australian computer, ASD is unable to assist any Australian. So imagine a scenario now where that syndicate can get itself back up and up and running again. That malware is still sitting on the phones of thousands of Australians and could start beaconing back to those criminals, and that threat would be re-enlivened, if you like. ASD cannot, under its legislation, take any action to address that. However, the warrants proposed in this bill, for example, and the AFP touched on this as a case study in their own submission, would allow the AFP to prevent that future crime from occurring by assisting Australian victims, and it's not something that ASD can do. So that's an example where we will be able to operate, assist and support, but also, I hope very clearly, where ASD's powers end and the powers of the AFP and ACIC in this regard might begin.
Okay, so the reason why I asked that question is that, as I'm sure you're well aware, there at least be some Australians who are comforted to know that you and the talented staff you employ do what you do outside of Australia, but who may have some reservations about those same skills being deployed in Australia. So what reassurance can you provide them that the assistance that you'll provide through the AFP is something that they need not worry about, that there will be sufficient safeguards to ensure that what we've authorised you to do outside of our jurisdiction in a necessarily more an easier environment for you to operate in won't occur to the same degree within Australia?
Well, the functions that I outlined that are set out in Section 7(1)(c) with respect to preventing and disrupting cybercrime explicitly limits ASD's activities to being those undertaken by people or organisations outside Australia. So our Act that governs our functions expressly prohibits it.
Okay, thank you very much. That clears up all the issues I had, and I believe that's at least Mr Dreyfus's questions for now. So I thank all witnesses very much for your attendance and your assistance this afternoon. As Mr Dreyfus flags, I imagine there will be significant questions on notice for you, which we'd be very grateful for your prompt assistance with. But on that note, I declare the committee adjourned.
Thanks, Chair.
Thank you, Chair.